right, let's go on the record. Good morning, everyone. This is Division 3 of Gwinnett County Superior Court. I'm Judge Deborah Fluker. Today is Thursday, August 10th, 2023. This is the continuation of the criminal jury trial in the state of Georgia versus Austin Tybre Ford, 23B 00981-3. All parties are present for the state. Mr. Ford is present in court, seated next to each of his counsel. Mr. Lawrence Lewis, was there a matter that you needed to have the court take up?
Judge, first I want to thank you for coming in a little bit early. I anticipated that I would argue a motion this morning in regards to having the court exclude Austin Ford's mother from the courtroom.
Can you close the door? We're not ready yet. I just need you to... Okay, I just need you to close that door for me.
I searched and searched and then realized that the motion was not actually reduced to writing. It was an oral motion that was argued, but I did find the transcript of that motion. So by the time I did that with all the other things going on, two of my primary values ended up coming into conflict. One, do not waste time. Number two, do not break your word. So I had to make a choice. Am I going to actually not break my word and reduce this motion to writing? And I decided I'm not going to do that. And I didn't want to come in and really just argue an oral motion without reducing anything to writing. I wanted everybody to be able to see it in writing. So I'm not going to pursue orally the motion that I thought was in writing to exclude my client's mother. She's not here in the courtroom now. I haven't seen her. She may not show up. I'm going to deal with whatever kookiness comes up today if she decides to come, as opposed to now. If after the jury has the case and they're deliberating, I feel like I need to address that issue, we'll deal with it then. But I just didn't think it was a good use of time last night, since I had to do cross, closing, and directed verdict motions, review the jury charges. I didn't think it was a good use of time. So I won't be pursuing any motion to exclude Mr. Ford's mother from the courtroom this morning. Thank you, Judge.
All right, just to perfect the record a little bit more, the court had to address an issue last night after the jury was excused that dealt with an allegation of an improper use of a cell phone device in court without prior permission of the court. After that was addressed last night, the court ordered the Gwinnett County Sheriff's Office to seize the cell phone of Miss Sheila Holly. I've prepared an order that's been provided to the sheriff this morning that authorizes them to hold that cell phone until further order of the court. I'm also in the process of having my staff file a second order that outlines the allegations of contempt of Miss Sheila Holly and schedules a show cause hearing on the issue of contempt for Miss Holly that has been scheduled for Wednesday, August 16th at 9:30 a.m. here in courtroom 3F. Obviously, neither the state or the defense are actual parties to that show cause hearing for contempt, but because it arose during the criminal jury trial proceedings, in this case, you will both sides will be copied on that order and notice of hearing. Your appearance is not required. Deputy Odom will also receive a copy of that order. As she was involved in seizing the phone, she will be required to appear for that scheduled hearing on August 16th. Anything else on that issue from the state?
No, Your Honor.
From the defense?
No, thank you, Judge.
All right, I believe we have several jurors that are still missing. It's not quite 9 o'clock when they were scheduled to return. Are there any other issues that the court needs to address while we wait the arrival of all the jurors?
None from the state, Your Honor.
No, thank you, Judge.
All right, Mr. Lawrence Lewis, if you will inquire of Mr. Ford if there's a need for me to do any further inquiry of him this morning regarding his rights and decision to testify or not testify.
Nothing's changed so far about that, Judge.
All right, then let's just be in recess until the remainder of the jurors arrive, and hopefully we'll be ready to resume the trial with Detective Carter on the witness stand close to 9 o'clock.
Thank you, Judge.
Thank you, Your Honor.
All right, thank you. Mr. Ford is back with the deputies. If you are not an officer of the court, your cell phone must be powered completely off, not on silent, powered off. Please check your phones. We're ready, Mr. Wooten. Right, good morning, members of the jury. Welcome back. We are ready to resume with the trial. Detective Carter remains on the witness stand and she remains under oath. I believe we are with the defense on cross-examination.
Good morning, Mr. Lewis.
Yesterday, you indicated that you had a committee of homicide investigators that sort of brainstormed what could have happened when Tori was shot on July 27, 2021. Is that right?
Yes, sir.
Okay. Do you recall which homicide investigators were participating in that?
Yes.
Okay.
Detective Dormany,
Dormany.
Detective Dunning,
Okay.
Detective Jorstad,
Okay.
Lieutenant Millsap, Sergeant Millsap at the time,
Okay.
Lieutenant Brookins, who is now Major Brookins, Sergeant Hegwood,
Okay.
Sergeant York,
Okay.
now Sergeant Smith.
Okay.
I'm going through the cubes in my head because we've had movement since then.
Okay.
Detective Daniel, I don't know if I said his name yet.
You didn't.
Who's behind me? Sergeant Richter, he's Lieutenant Richter now. I'm thinking. That's all I can think of at this time.
All right. Do you recall if it was one brainstorming session or more than one?
Multiple.
Multiple.
Yes.
Do you recall if they were held relatively close to one another, or if they were done sort of 6 weeks apart, 8 weeks apart?
They were constantly done throughout the course of the investigation. Every time we get a new piece of evidence, we discuss it amongst each other and discuss it related to other evidence we receive.
Okay. But I thought what I heard yesterday was based on where the shell casings were located. So I understand that detectives assist one another in various aspects of their job. Is that fair to say?
Yes, sir.
Some homicide detectives come from gang, and so they have more of a gang perspective. Other detectives come from vice, so they have a vice perspective. They all have a different perspective before they come to homicide. Is that right?
Yes.
Okay, some have done burglary, some have done other things, and I understand that. I'm asking specifically about the shell casings because as I listened to you yesterday, I thought I heard that the theory of concerning suicide versus homicide was determined by the way the gun was facing in the shell casings. Did I get that right yesterday?
That
what
is
you
a
said?
very small piece. That was not the whole determination.
Okay, all right. Well, I want to return to just that piece.
Okay.
In terms of brainstorming sessions with the other homicide investigators, about how many times did you brainstorm about the direction of the gun or how the gun must have been turned in order for the shell casings to land where they landed?
Multiple times.
Okay, all right, good. So again, there was more than one brainstorming session amongst a number of the homicide detectives where you talked about how the gun must have been positioned in order for the rounds to land where they landed. Is that fair to say?
Yes.
Okay. Do you recall approximately what date the brainstorming sessions specifically involving the shell casings began?
I don't know the exact dates. Again, they were all based on like different information we received.
Okay, and based on the placement of the shell casings, I understood that you, in conjunction with maybe some other homicide investigators, speculated that the gun had to be turned a certain way. Is that right?
It's a theory, yes.
Okay, all right. And before I ask you to demonstrate that theory, I want to understand what you and the medical examiner might agree on, okay?
Okay.
September 2021, how long had you been a homicide investigator?
A couple weeks.
And prior to coming to the homicide unit, you had been in what unit?
Robbery.
How long had you been in the robbery unit?
4 to 5 months.
And prior to the robbery unit, where had you been?
The special victims unit.
And how long had you been in special victims?
Since March 2020. So a couple months. About maybe a year. Yeah.
Okay. March of 2020. So and you were an investigator in robbery, right?
Yes, sir.
And you were an investigator in special victims, is that right?
Yes, sir.
So if I understand you correctly, you were an investigator for about 18 months beginning in March of 2020 to September of 2021 when you were investigating this homicide, is that right?
In the actual CID unit, I did do some road investigations with the West Precinct Crime. It's called the CRT unit. CRT stands for Community Response Team, but sometimes we'll get assigned certain cases that may not go up to detectives.
Okay, in terms of your being an official investigator, did that begin in March of 2020?
I went to CID in March 2020, yes.
March 2020. So you had been an investigator about 18 months prior to you being assigned this homicide. Is that right?
Yes, I was assigned to CID for 18 months.
And only because you had been in homicide for a few weeks. Was this your first homicide case?
I believe so, that I was lead on.
Okay. All right, so let me take one step back. Based on your experience as an investigator overall, did you think that Tori had been shot in Yellow River Park or somewhere else?
I think she was shot in Yellow River Park at that time.
Okay. And I want to make sure we keep these pronouns straight. 2023, there's a lot of debate about pronouns. I want to make sure if you say I, you mean you, as opposed to what another investigator may have thought. Another homicide investigator that may have been talking to you during a brainstorming session. Does that make sense?
Yes. May I ask for clarification?
Yeah.
When you ask me a question like that, do you want me to say me as well as other investigators, or do you just want me to give my opinion? I apologize.
No. It's fine. Let's get it clear. Sometimes you may hold an opinion that you may want to bounce off another investigator.
Absolutely.
Sometimes you may just have a question, another investigator gives an answer, and you adopt that answer because it makes sense to you based on your experience. Does that make sense?
That's possible.
In that regard, both of those, in my mind, are your opinions. Does that make sense?
Yes.
Sometimes there will be a disagreement. I'm sure there are disagreements.
Absolutely.
When you've got 8 people looking at some facts, right?
Yes, sir.
And so if, in fact, you believe something, but a lieutenant or major or somebody else disagrees, and you feel for whatever reason compelled to adopt their position, that's fine too. That's their position. You adopted it, but you're still not certain about it. Does that make sense?
It makes sense, but if they give me their opinion, I'll still voice my opinion, and we'll have a discussion. Yes.
And so I means you believe it.
Yes, sir.
Yes. Versus we versus they.
Yes, sir.
Okay, good. We're on the same page now. So we'll go back. Based on your experience, did you think that she had been shot in Yellow River Park or somewhere else?
Yellow River Park.
Okay, and based on your experience, how far did you think the gun was from Tori's head when she was shot?
I went based off the medical examiner's report in that one.
Okay.
And it was 10 to 12 inches,
I got
the
you.
barrel.
I got you. Based on your experience, were you comfortable that the medical examiner got that right?
Yes.
Or did you not know?
I mean, I trust Dr. Terry.
Okay.
And we did have a meeting about it afterwards for further clarification.
Okay, when you say afterwards when?
After I took over the case.
Okay, and I'm going to have some questions about the chronology, but we'll return to that. Did you think that Tori was standing, sitting, or lying down when she was shot?
We discussed that. I wasn't sure.
Okay, when you say we, are you talking about you and Dr. Terry or you and the other investigators?
Dr. Terry as well as the other investigators.
Did you speak to Dr. Terry first before you had the committee of homicide investigators talk to you about whether she was sitting down or lying down? Do you remember the chronology? Who you spoke to first?
It was the detectives,
Okay.
Dr. Terry, and then the conversation continued after we spoke with Dr. Terry.
Okay, and in terms of her standing, sitting, or lying down when she was shot, did you have any sort of opinion regarding that?
I had theories, but again, there was nothing for certain.
Okay, and although Dr. Terry said that she was lying down, did you feel like, based on your experience, I'm not sure if that had happened?
You said based on Dr. Terry saying she was lying down?
Yes, Dr. Terry has testified, has indicated that Tori had to be, based on blood flow, had to be laying down and looking upward to the sky when she was shot. Did Dr. Terry ever express that to you?
Not in our initial meeting.
Okay.
In follow-up stuff, and then when reading the report, that was not specified.
Okay, so not initially and not reading the report. So I'm gonna backtrack, understanding the answer you just gave, and said, did Dr. Terry ever tell you that the science says Tori was laying on her back looking upward when she was shot?
Yes, it was months later.
Okay, it was months later, but it was before Dr. Terry's testimony back in April of 2023. Is that right?
It was, I believe, it was shortly before that.
Shortly before that, right. So even if you learned in April of 2023, Dr. Terry's position is Tori was on her back looking upward. You knew at least 3 months prior to your testimony here yesterday that was Dr. Terry's position. Is that right?
Yes.
Okay, and so I'm asking you, having digested what Dr. Terry said 3 months ago under oath, did you, with your experience, think that she was standing, sitting, or lying down when she was shot?
After learning the information, Dr. Terry told me a couple days and weeks prior to April of 2023, I did, after listening to her, agree that she was laying down.
Okay, and did you think that she was laying on her back or stomach when she was shot?
Based on Dr. Terry's statement, she was laying on her back.
All right, and did you think that she was looking skyward when she was shot?
I think she was, yeah, looking up.
Okay, and based on what you could observe, were there any defensive wounds on Tori at all?
Not that I observed. She did have some little marks on her fingers, but we weren't able to tell if it was defensive wounds. It looked like maybe she had some acrylic nails that she ripped off, but there were just small little nicks.
Okay, and so I want to make sure I understand. When you got on the stand yesterday and you testified about how the gun was positioned and the shell casings, you agreed with the medical examiner that Tori was lying on her back and looking skyward when she was shot. Is that right?
That is correct.
Okay, so whether Tori shot herself or was shot by somebody else, it appears, based on that fact, that Tori was a willing participant in the shooting. Is that fair to say?
I can't say for certain. I can say that she was laying down.
She was laying down, she was looking skyward, there are no defensive wounds, and she was shot in the head with the gun barrel being parallel to the ground. Is that right?
That's a theory, yes.
Well, wait a minute. You say that's a theory. That appears to be Dr. Terry's theory under oath as you heard it in April of 2023, right?
Yes.
Okay. Do you have a different theory concerning the barrel being parallel to the ground?
Parallel or perpendicular? So there's different. So that's what the discussion was. I apologize. I thought you were asking a different, in regards to something different.
It's fine. It's fine. These
two pins are parallel to one another, correct?
Correct?
Okay. And that's,
Perpendicular?
okay, good. So we're on the same page. The barrel of the gun, when Tori was laying on the ground, whichever way the gun was facing, the barrel of the gun had to be parallel to the ground. Did you agree with that?
Can you demonstrate? Because I don't know which way you're saying. Like, are you saying if it was parallel to the ground in this way or up this way? I'm sorry.
The barrel of the gun is parallel to the ground no matter how I turn the gun. That's still parallel to the ground, correct?
Okay, I get what you're saying. Yes.
Okay, good. So I want to make sure you and I are on the same page. Dr. Terry's position was that the gun barrel was parallel to the ground when Tori was shot. You understand that?
I understand what you're saying.
Okay,
Yes.
and so my question, when you say that's a theory, is that a theory that you accept in the case, that the barrel of the gun was parallel to the ground when Tori was shot?
Yes, I do.
Okay, all right.
I thought I was focusing on the handle. I apologize.
It's fine. We'll take our time. We're gonna make sure we're all on the same page. So, whether it was a suicide and she shot herself, or an assisted suicide where somebody else shot her, it appears that Tori wasn't fighting with any perpetrator when she was shot. Is that fair to say?
There's no evidence of that, no.
Okay, good. So why would you tell her parents on April 15, 2022, that Tori was not suicidal? Why would
Objection,
you?
Your Honor, relevance? I did not see where conversations between Detective Carter and the Lang family have any bearing on whether or not this defendant committed the crimes before the court or where this line of questioning is going.
No, it's not conversations. It's not two-way. I'm just asking, why did she say, based on now what she's told us, why did she tell the Lang family that?
The detectives is on cross-examination, and I find this line of questioning to be relevant for cross, so I will allow it over the state's objection.
Why would you tell Tori's parents on April 15th that you knew that Tori was not suicidal?
I don't remember the exact words that were said during that conversation. I do recall discussing the details of the case after reviewing the evidence that I had in the case, and I did state to them that I did not see any evidence indicating that she could possibly be suicidal. There are certain traits and actions that we look for, and I said that I could not locate anything to indicate that she was.
You know, just looking at the body on the ground, Tori, you agreed with Dr. Terry, Tori laid down on the ground, facing skyward, when she was shot with a gun where the barrel was parallel to the ground, where there appeared to be no fight, right?
Yes, that's the scene.
So whether it was assisted suicide or suicide, it appears that she wanted to be shot.
I can't say for certain that that was what happened.
Was there any indication that she was resisting any part of being shot?
There's no evidence of that.
All right. You recall on April 15, 2022, you met with Tori's parents, right?
Yes.
And that was the day you told them that you were going to be taking out warrants on Austin Ford?
Yes.
Okay. And that meeting was recorded, correct?
Yes, sir.
Have you reviewed that recording in preparation for your testimony this week?
I've looked at it briefly, yes.
Okay. Do you recall that portion where you said, oh, it's clear Tori was not suicidal when you spoke to her parents in that recording?
It's possible I said that.
Okay. The barrel of the firearm being parallel to the ground, you indicated already you only heard that a few weeks prior to Dr. Terry's sworn testimony in April of 2023. Is that right?
Yes.
Okay. When did you come to an agreement that that's how Tori must have been shot? I understand you didn't hear it till early April, maybe the end of March. When did you come to an agreement that Dr. Terry was right about the gun barrel being parallel to the ground?
When she discussed the blood flow, I'm not a doctor, so when she when she said that that gunshot would cause someone to start bleeding immediately, I was like, okay, and I agreed with her because that discussion had never come up in previous conversations.
Okay. It was September 18th, 2021 that you replaced Sergeant Smith as the lead investigator. Is that right?
Yes, sir.
Okay. And were you aware that Dr. Terry's report had been completed about a month before you became the lead detective in the case?
Yes.
All right. Do you recall reviewing Dr. Terry's medical report before you went out to Yellow River Park to recreate the scene?
Yes.
What day did you go out to Yellow River Park to recreate the scene?
I went out there just to visit the scene and shortly after receiving the case, and then I went out there to test other theories and try to recreate the scene. Was it?
That's a poor question by me.
Yeah.
Here's a better question. I'm glad you agree. Here's a better question. At some point in time, you went out to the scene dressed in clothes similar to what Tori wore and sat down on the ground.
Yes.
Remember that?
I did.
Somebody was dragging you to see what type of pattern that would leave on the clothing. Do you recall that?
I do.
And all of that was recorded. Do you
Yes,
recall
sir,
that?
it was.
Okay. Do you recall the day you did that?
I don't know the exact day I did that.
Okay. Do you recall if you had spoken to Dr. Terry before you went out to do that?
I did.
Do you recall if you went out to do that first or if you had spoken to Dr. Terry first?
I spoke to Dr. Terry first.
Okay. You also, in addition to doing that, you created this sort of life-size doll with braids to see how the braids would fall when the body fell.
Correct.
Okay, and you dropped the body and you sort of videotaped that also. Is that right?
Yes.
Do you recall what date you did that?
That was the same day I went out to the scene and was drugged with the clothing.
Okay, let me ask you this. How many hours did you spend creating that doll and recording the dropping of the doll to determine how the braids would fall when the body dropped?
Oh, the creating of the doll, I just went and bought a wig that had approximately 36-inch braids and then put it on a doll that we had at our training facility.
Okay, and you recorded that. How long did that take?
Maybe an hour max for that portion.
Okay, and at that time, you didn't know that Dr. Terry's position was that Tori was lying flat on the ground looking up. You didn't know that at that time. Is that fair to say?
No.
Before you met, or during the time that you were meeting with the Committee of Homicide Investigators, did you know the type of gun that was missing from Tori's mother's residence?
I did.
9mm Sig Sauer P365, correct?
Yes, sir.
All right. Did you fire any cartridge casings that were the same? Well, let me ask this question first. Did you know that the fired cartridge casings recovered near Tori's body were the same as the ammunition held with Tori's mother's firearm?
Yes, I was.
Okay, that's the Aguila 9mm?
Yes, I believe so.
Okay. And when you met while you were meeting with, I understand there were multiple meetings with the other folks in the homicide unit. When you were meeting with the Committee of Homicide Investigators, did you think that Tori was shot with her mother's firearm?
I believed it would be a possibility.
Okay, and in speculating about that possibility, and in speculating about how shell casings may travel out of the ejection port, did you fire any Aguila 9mm rounds out of a P365?
I did not.
Okay, do you recall yesterday you and the prosecutor were talking about the positioning of the gun as it related to Tori's head and how the rounds would have been ejected from the gun. That's you had a conversation on the stand about that yesterday. Is that right?
I did.
Okay, but there was no actual firing of any P365, any firing of Aguila 9mm rounds to see how they might jump out of the ejection port on the 365. Is that right?
Correct. Would you like me to explain why?
Oh, yes, absolutely.
Okay. So even if you have the same exact firearm, same make, same model, there's a lot of factors that are going to come into play. It could be the same ammo. It could be the same firearm. It could be different people shooting the gun. There's going to be a lot of different factors. So the placement of where it lands, if you're holding it, if we know the exact place that's being held, it could go forward, it could go back. There's going to be a ton of different reasons. And it's going to be a ton of different factors that are going to cause the placement, and even it can be the same person if they loosen their grip. It could cause them, the shell casings, to go a different way as well. The main, what we struggle with is because we don't know exactly how the gun was being held. So when I say that someone could be holding the gun the same exact way, there could be a bunch of different factors that go into that. The biggest factor that when we look at is the manipulation of the gun, based on the positioning of the ejection port. So if someone's holding it like this, the ejection port's going to be on one side. Someone's holding it like this, it's going to be on different sides. Someone's holding it upside down. So that's what I mean when I say that we discussed those different theories and where the ejection port and stuff was.
But as I listened to your testimony yesterday, I was left with the impression from your testimony yesterday that how the gun was positioned when Tori was shot was totally dependent. That where the shell casings landed was totally dependent on how the gun was positioned when it was fired, right?
Not totally, no.
Let me ask you this question, Carter.
This were an actual weapon, and I was firing it, P365, and I was firing 9mm rounds out of it. Same hand, same rounds, same gun. Is it possible that one round would land over near the door?
That's kind of far, maybe towards the defendant's table. The door, I mean, I guess it could be possible. That's still pretty far.
Okay. Is it possible that one round might go up and land on the light fixture from the ceiling light fixture?
No, I don't think so.
possible.
That's high.
That's fine.
Yeah.
Not possible. If I fire, is it possible that one round would go backwards and hit the prosecutor here, from the same position? Is it possible if I fire one, it gets ejected and bops the female prosecutor in the head?
Yes, sir.
That's possible?
Yes, sir.
Okay. And if I fire 4 rounds, the 4 rounds may land in 4 totally different places. Is that right?
Yes, sir.
Okay. With that understanding, I'm going to ask you to come down. I'm going to ask you to come down, because I need to understand your theory. This is the gun that everybody believes was used, correct?
Correct.
Okay, here's Tori's head. Here's her body. Right? Here's her head, here's her body, right? Okay, so explain to me, based on where the rounds landed, how you believe the gun had to be fired.
So based on so we did discuss it this way.
If you could keep your voice up, Detective.
Oh, I'm sorry. So you want me to discuss all theories we talked about, or just
Okay, no,
one?
you can discuss all the theories, but I want to discuss them one at a time. Theory 1.
So we did discuss it being like this because of the medical examiner's determination. So from there, you do the 12 in front, 12 in the back. But the ejection port is still facing up. And like I mentioned yesterday, you have gravity coming into play. So that could affect the ejection as well. So it could come up, and then so that'll prevent it from coming as high. But again, we don't have the exact firearm, and there's what is going back and forth.
Okay. I want to make sure we're talking about the right thing. Listen. Don't worry about the jury. Jurors are going to move. The way you position the gun right here, I'm thinking is incorrect because it appeared.
Okay, I didn't know where.
Here's her head. Here's her body.
Yes.
I want to make sure we're on the same page. So, theory 1 is the gun was that's about what, 8 inches, 10 inches. There we go. Okay. Theory 1. The gun had to be held in that position right there, correct?
Yes, we discussed this.
From that position right there, based on Dr. Terry's testimony, could Tori have pulled the trigger with her thumb?
Yes.
Okay, good. Theory 2.
Theory 2 was up like this.
Okay, theory 2, up like that,
Yes.
all right?
And
Okay.
then, again, the ejection port would be out.
Okay.
And then the discussion we had was, again, because it can go up, back, all over.
Right.
But the distance that it was past her feet,
Right.
that's where it came into discussion with the whole gravity thing in play. Because if it's like this, it's not going to go as far, in theory.
Okay.
These are the discussions we have.
Okay.
Because that's when we come in where we talk about all of the details of the case and everything.
Okay.
So that's where the discussion came in with the shell casing.
Okay, good. And from that position there, theory 2, from
Yes.
that position there, with the actual slide facing towards the ground, can Tori pull the trigger with her thumb?
It would be difficult, but yeah, I believe so.
Is it possible?
I think so.
Fantastic. What's theory 3? What's theory 3 with the weapon?
Oh,
The
those
weapons
were
facing-
those were the two ones we discussed.
That's
after.
it.
Yeah.
And from both of the positions that you discussed, theory 1 and theory 2, Tori can pull the trigger of that gun with her thumb, correct?
I believe so. Yeah.
Okay, thank you very much. Thank you.
Your Honor, if, as Mr. Lewis used a prop, it was a styrofoam cup in a baseball, does that need to be marked as exhibit in there as opposed to?
I don't think it does, Judge. I don't think it does. But the court will rule. And if I could, because that baseball was signed by folks that I coached, I'll substitute a new ball. If that needs to be, I got balls in the car. I could substitute another ball if that becomes an issue, Judge. That's not an issue. You'll think about it. We'll get back to
I
that.
don't need to think about it, Mr. Lewis. We'll mark it. So what is the next defense exhibit? Is it?
3?
Sure.
3.
All right. So we'll mark the styrofoam cup and a replacement baseball.
Yes.
As defendants 3 for admitted for demonstrative purposes. Is that without objection?
I'm probably gonna call it like 3A for the cup and 3B for the ball, Judge. That'll probably work. That'll
you.
work. Thank you very much. Detective, April 15, 2022, you told Tori's family that you were taking warrants out for felony murder and aggravated assault against Austin Ford. Is that correct?
I did.
All right. You explained to the family at that time that was audio and video recorded. Is that right?
Yes, sir.
You explained to the family at that time that Austin had done nothing but lie to you. Do you remember that?
I probably did say that. Yeah.
Okay. And assuming that Austin had done nothing but lie to you, was there any technology, geofence, cell tower triangulation, Google Maps, anything that placed Austin in the park when Tori died?
No, just in the area.
Okay, so the only evidence that you have that Austin Ford was in the park is Austin Ford's testimony. Is that right?
Yes.
Okay. Were there any witnesses to Austin driving Tori's vehicle at any time on July 28th?
No, not that we were able to speak with.
And
Or
you
we
didn't
could-
have, and there's no other circumstantial evidence that put him in the park. Is that right?
Other than his statement.
Gotcha.
Yeah.
Now, I thought I heard it. 11:05 p.m. Cell phone towers put Austin at Annistown and Deshawn. Is that right?
No.
What was it? Google?
Wi-Fi. Yes.
Wi-Fi put Austin Ford at 11:05 at Annistown and Deshawn. Is that right?
Yes.
And
Through
at
the Google information. Sorry. Yes.
Got you. That's fine. And at 11:44 p.m. Austin is on Rockbridge. Is that right?
Yes, sir.
Okay. But you don't have any technology that puts him in the park. Is that right?
That's correct.
And part of the reason may be explained by the fact that Austin tells you he turned his phone off. Is that right?
Yes, sir.
Okay. The cell tower, and I don't know if we went over this, cell towers give you triangulation. The cell tower is broken down into thirds. Is that right?
I wouldn't say thirds, but yes, it is broken down based on triangulation in the azimuth direction. Yes.
Okay, and when I say thirds, it's like a pie. The cell tower itself there's one side of the cell tower, then there's a second side and the third side of the cell tower. Is that right? Do you understand is that your understanding how the cell tower technology works?
In a way, but slightly different.
That's fine.
It's not as simple as on the west side. It's not as simple as on the north side or the east side.
I got you.
It's based on the degree in the azimuth and what it points to.
Okay, in terms of one, whether we call it a third, a fifth, half of the cell tower, the cell tower gives you a 2-mile radius in that piece of the pie. Is that fair to say?
Yes, sir.
Okay. In terms of Tori's social media accounts, did you check Tori's social media accounts?
I did.
All right. And which social media accounts did Tori utilize?
We had her Instagram account. We got access to her Facebook, but she didn't seem to be active on it.
Primarily Instagram, is that right?
Yes, sir.
And did the prosecutor ask you a question yesterday about drugs being in Tori's system?
Yes.
Okay. I thought your testimony was that you learned that Tori didn't have any drugs in her system when the medical examiner extracted bodily fluids to send them to be analyzed. Is that right?
I believe the prosecutor asked about prescription narcotics.
Okay. Well, she didn't appear to have any. She didn't appear to have any illegal street drugs in her system when the medical examiner extracted bodily fluids and sent it to be analyzed by GBI. Is that right?
No prescription drugs, no.
Okay.
Illegal narcotics, methamphetamine, stuff like that, yeah.
That's right. And there was no alcohol in her system?
I don't recall. I don't believe so.
Okay. No marijuana, correct?
I don't recall that because I believe we were looking specifically at the prescription. It's possible she may have had marijuana, but I don't recall the exact reading of that.
Okay, that's fine. The first time you spoke to Austin on the phone, October 25th, 2021, correct?
Yes.
Spoke to him a little over an hour?
Yes, sir.
Okay, and that's the conversation the jury heard yesterday, is that right?
Yes, sir.
And on the phone, Austin told you that Scoop had gotten Tori mixed up with drugs, is that right?
Yes, sir.
Austin specifically said Perks, Beans, and Zans, is that correct?
Yes, sir.
You understood that to mean Perks to mean Percocets, right?
Yes.
Beans is ecstasy?
Yes.
And Zans is Xanax?
Yes.
All right, did you have to ask any drug investigator about that, or did you come to that knowledge in your experience as a police officer?
In that particular conversation, I just assumed what it was because there's common knowledge of it, but it is possible for like the street manufactured drugs to contain other substances, even though it's called Perks, Beans, of the such.
And when you say common knowledge, you talk about common knowledge for the people that come in this building and do this work.
Yes, I apologize.
Yeah,
common knowledge in my profession.
You understand, average person may not know beans is ecstasy, right?
Yes.
Okay, I got you. In terms of Percocet, do you know how long that remains in your system when you take Percocet?
I do not.
Do you know how long ecstasy remains in your system when you take ecstasy?
I do not.
Do you know how long Xanax stays in your system?
I do not.
Do you know if you're taking them in combination, if you're taking Percocets and ecstasy together? I don't know what that's called or if they do it, but do you know if that's done in combination? Do you have any idea of how long that would remain in your system?
I do not.
Okay, so the fact that the medical examiner takes some bodily fluid, sends it to GBI, and GBI says that there are no street drugs in her system, that doesn't mean that Austin wasn't telling the truth about Scoop giving Tori drugs, right?
Because she didn't have it in her system
That's
at the
right.
time? Oh, no. I mean, he could have given it to her in the past. Yeah.
The first time you spoke to Austin face-to-face, that was at the Clayton County Jail?
Yes, sir.
Okay, and at that time, he had been arrested on a stolen gun charge, is that right?
Yes, sir.
Did you know what type of gun it was?
I did not. I did, but I can't recall at this time. It was listed in a report. I did call Clayton County to find out what it was.
Not a P365?
It was not, no.
Okay, so there was no possibility that it might have been the gun that Tori, that that was present when Tori was shot. Is that right?
It was not, no.
Okay. And Austin explained in the recording, I think that the jury saw yesterday, that he purchased the gun on the street. Is that right?
Yes, sir.
Said he didn't know that it was stolen, but he purchased it on the street. Is that right?
Yes, sir.
He indicated, Austin did, that he felt he needed the gun to protect his family. Is that right?
Yes, sir.
Now, he wasn't married at the time, was he?
No, he was not.
So when he's talking about his family, did you think he was talking about the girlfriend and her baby?
Yes, Jalen Messiah, yes.
Because he was playing the role of father to the child that he wasn't a biological father of. Is that right?
Yes.
Okay. Do you recall asking him why he didn't purchase a gun at a pawn shop?
I did.
And you asked him that because you had forgotten he wasn't 21.
Yeah, I knew he wasn't 21, but in the conversation when I was talking to him about it, it slipped my mind.
All right. Do you have to be over 21 in Georgia to legally purchase a gun?
Yes.
All right. And based on what he had told you about how he was hopping from residence to residence, did he appear to be unstable at the time you were speaking to him? Let me rephrase that. For the way Austin was telling you he had been hopping from residence to residence in terms of his living situation, did you believe that he was unstable prior to being arrested for the possession of the gun charge?
Unstable in what way?
Unstable. I know, you know, when you leave here today and you say, I'm going home, you know the address you're going to, and you're pretty confident that's where you'll be at Christmas. When I go home, I know where I'm going. I'm probably, unless I'm dead, I'm probably going to be living there Christmas. My housing situation is stable versus I don't know where I'm going to be at Saturday. I don't know where I'm going to be at next Saturday. Mm-hmm. Labor Day is going to find me here. Thanksgiving, hopefully my auntie will have her house set up. Unstable. Did you think? I
just wanted to make, yes, this unstable and living environment. I just wanted to make sure I was understanding the question correctly.
Unstable.
Yeah, that's what I wanted to make sure.
Unstable in terms of where he's living. And he had indicated that he had only recently gotten a car, right?
Yes, they got the car a couple months. Well, in that interview, no. When I first talked to him on the phone, they had just gotten the car.
Okay.
So it was some months before.
I probably mixed those two interviews because I remember you said congratulations on getting the car. He had just gotten the car. Is that right?
Yes, that was back a couple weeks before the October interview.
I got it. Did you know if he was working at all when you went to interview him face-to-face in Clayton?
He was actually, we discussed, he said that he was working. He had gotten an overnight job, I believe, at FedEx. It was one of those companies. And he had he worked at Amazon briefly and stuff, but yes, he was. Okay.
He was working, but still hadn't established a stable residence prior to his being arrested and coming to Clayton County. Is that right?
Yes, sir.
Okay. And you, if I understood what I heard on the recording correctly, you only knew he was in Clayton County because Tori's mother informed you he was there. Is that right?
Yeah, that was a lie.
Okay. Listen, and the law allows police to lie to suspects. Is that fair to say?
Correct.
Let me ask this question because I don't know the answer. Does the law allow police to lie to lay witnesses who are not suspects?
To lay witnesses?
Yeah, I'm an eyewitness. I'm an eyewitness to something. You, as the detective, think that I'm not sharing everything with you. I'm not a suspect. I'm an eyewitness. Does the law allow you to lie to me to test my eyewitnessing capability?
I'm not 100% sure on that, but I can't think of a reason why I would do that.
Okay. But it's definite that you can lie to a suspect. If I'm a suspect, you can tell me you have a fingerprint when you don't have a fingerprint, correct?
Correct.
Good. You can tell me that I'm on video when I'm not on video, correct?
Correct.
You can tell me that there's some blood left behind even though there's no blood left behind. Is that right?
Correct.
Okay. So tell me, you indicated to Austin that Tori's mother had informed you, but how had you learned that Austin had made it to the Clayton County Jail?
A post his girlfriend made on Instagram.
Okay, so you were following what was going on social media, is that right?
Correct.
Okay, to try to catch up with him.
Yes.
Because now, and here it is. This is your impression. Were you left with the impression he was dodging you? Or were you left with the impression he was sort of busy trying to get his living situation stable before he sat down and talked with you? Or both? Or neither?
In my opinion,
Yes.
I believe he was dodging me.
Okay. Scoop. You never interviewed Scoop, did you?
No,
All right. Did you ever speak to Scoop?
no.
Okay. So did you? I thought you indicated that Scoop was Tori's boyfriend, correct?
That's what was told to me.
Told to
Yes.
you.
Yeah.
You weren't able to confirm that because Scoop didn't talk to you.
No, he wouldn't speak with
I
me.
thought I heard you say at some point in time, and I don't know if it was the truth or a lie, that Scoop refused to speak to you. Is that true? Did he leave you an email or a voicemail saying he refused to speak to you?
No, refuse may be the wrong word. I assumed he didn't want to talk to me because I did call him multiple times. I reached out to family members. I talked to other people in the case that knew him and asked them to reach out, of the sort. So if refuse may have been the wrong word, that might have been an assumption on my part.
Oh, but it was clear you were making all the efforts and he was making no effort to contact you. Is that right?
That's correct.
And if I understood what you testified to yesterday, is you learned through Scoop's social media that he was involved with other females other than Tori. Is that right?
Yes.
In fact, you created an alibi for Scoop through his social media based on the fact that you knew that he was with another female over near Six Flags. Is that right?
I couldn't say for certain. He was communicating with a female that did have ties to the area where his phone was pinging, and they were discussing meeting up.
Okay. So it appears circumstantially from the social media and from the cell phone technology that he was in the Six Flags area meeting up with a girl. Is that right?
Yes.
Okay. And the way you learned about his involvement with this other female through social media, is that the same way Tori could have learned?
If she had access to it, but I don't think she would have found out the same way.
Okay, and I guess
That I do.
Okay.
Yeah.
And I guess that's really my question. Does law enforcement have some type of special law enforcement access to social media that the public doesn't have?
Through search warrants.
Okay, did you get a search warrant to sort of monitor Scoop's social media?
Not to monitor, but to request records within a certain time frame.
Okay, and is that how you learned that Scoop was over in Six Flags with maybe a different female?
Correct.
Through the search warrant?
Yes, sir.
Okay, not just through publicly following him on social media.
No.
Gotcha. Thank you very much. When you spoke to Teresa, Tori's mother, she explained that Tori had recently been released from the hospital. Do you recall that?
Yes, I do.
Okay, she said that Tori had fainted.
Yes.
And when we say released from the hospital, did Teresa tell you how long Tori had been in the hospital?
I believe it was an overnight stay.
During that same interview with Teresa, Tori's mother also told you that Tori was acting irrationally. Do you remember putting that in your report?
I don't. Yes, if you could reference it. I can't recall the exact wording.
I'm going to mark it D4.
Thank you.
It doesn't have a page number, so I'm going to hand it up. I have your whole report. I don't know if that looks familiar.
It does.
Okay.
Yes.
That was a report that you prepared?
Yes, sir.
And I've tabbed it. You can read the whole page and the next page. I give you the prior page if you need it. I just want to make sure you're oriented.
Yes.
Where it's tabbed, it indicates that in your interview with Teresa Lang, Teresa told you that Tori was acting irrationally. Is that right?
Yes, sir.
Okay, and that was after Tori had been released from the hospital for fainting, is that right?
Yes, sir.
Okay, and Teresa told you, when you spoke to Teresa, Tori's mother, I'm gonna call her by her full name, Tori Lang told you that she wasn't sure why Tori would take her gun, is that right?
Correct.
Okay, Tori Lang never told you that she thought that one of Tori's friends may have entered the house and took the gun. Did she ever tell you that?
No, she didn't.
How many times did you speak to her after you were the assigned investigator on the case?
A lot.
More than 5?
Yes.
Okay, and in no conversation that you had with Tori Lang, did Tori Lang ever even speculate that one of Tori's friends may have entered the house, burgled the house, or snuck in, or walked in with Tori and ended up taking a gun? She never insinuated that at any time, did she?
No.
On April 8th, 2022, you did a buccal swab on Austin Ford, is that correct?
That's correct.
All right, you needed that buccal swab to compare it to the blood on Tori's leg?
Yes.
Okay, was there anything else you were gonna compare Austin's DNA to?
No.
Okay, so you took a buccal swab from Austin pursuant to a search warrant, correct?
Yes, sir.
He was cooperative, correct?
Yes, sir.
He took the buccal swab for the purposes of comparing Austin's DNA to the blood that was on Tori's leg, is that right?
Correct.
Okay, and you learned that the blood that was on Tori's leg was Tori's blood, is that right?
Yes, sir.
Didn't come back to Austin, right?
No, sir.
Didn't come back to anybody else, is that right?
No, sir.
Okay. I don't have any other questions, thank you very much. Judge,
Thank you.
D4 just for the record.
Any objection?
No, Your Honor.
All right, D4 is admitted for record purposes only.
Let's see, D4. Look at where your statement in D4, was it that Tori's mother said she was, just simply that she said she was acting irrationally?
Yes.
Or was it qualified?
What do you mean qualified?
Well, the defense attorney asked that, I guess, suggested that Tori Lang had concluded that Tori took her gun. Is that what you were writing here?
That's what I assumed. That's what I interpreted it as.
Okay.
Yes.
And that was based. When do you recall the conversation where this exchange took place was?
It should be Gwinnett County headquarters. Let me check really quick. So based on this portion, this was a summary of Detective Smith's investigation.
Okay.
Yes.
So
So it would that was those statements were made in her home.
So those statements were made in her home, most likely to Detective Smith.
Yes.
On the day she discovered that her only child, her 18-year-old daughter, had been found dead in Yellow River Park. Is that right?
Yes.
Is it fair to say that her own state at that time, her emotional state, would have been, what's the word I'm looking for? I don't want to say hysterical, but I want to say,
Judge, I'm going to object because she wasn't there. She wasn't the assigned investigator.
I'll withdraw the question.
All right, the question remains withdrawn and the jury will disregard it.
But those statements were likely made to Detective Smith, is that correct?
Yes.
And those statements were made during the only time Detective Smith met with Tori Lang, which would be on the day he notified them of Tori's death.
I don't know if that was the only time that he ever met with her.
Okay.
I reviewed his summary and some of his case notes and stuff, but I don't know if it was only the one time that he met with her.
That's fine. Now, while it's agreed that Tori lay down where she was based on Dr. Terry's findings, is that
Yes, correct.
right? And that there were no defensive wounds, is that right?
Correct.
And you told the other Mr. Lewis that it would be consistent with her laying down and accepting that she was going to be shot.
It would be consistent with her laying down and being shot.
Would it also be consistent with her laying down unaware that she was going to be shot and being shot?
Both are possibilities.
Describe for the jury all of the things that you take into account when you are deciding to take charges against someone who is suspected of committing a homicide.
We take literally everything into account. We go based off the scene, where we have people that come out, investigate the scene, our crime scene techs. We look at their case notes, we look at evidence on the scene. We speak to them sometimes about their findings. When we're on scene with them, we'll often ask them certain questions like, why don't we do this? Let's do this. And we'll ask them to do extra things. We look at statements made by the medical examiner. We talk to as many people as we can that are involved in the case. We look at cell phone records, we look at DNA, we look at internet search history. We look at every single piece in the case before we come to a decision. We often refer to that as like the totality. That basically, obviously, you guys know, it means everything involved.
And is it your role as the lead detective to look at the entire investigation, including witness statements, interviews, physical evidence, the findings of the medical examiner? Is it then your role to decide whether or not to take charges?
Yes, that's when we put everything together and make our decision.
It was asked whether or not police can lie during an interview.
Yes.
So could you tell a suspect who is finally making admissions that you believe him?
Yes.
Can you tell him that you're on his side?
Yes.
And is that accepted interview technique?
Yes.
I want to ask you just a couple of things about semi-automatic handguns and subcompact semi-automatic handguns. Do you carry a handgun as a police officer?
I do.
How often do you fire said handgun?
For the county quarterly, personally, a lot.
Do you fire it with the county to qualify?
Yes, I do.
And is that a requirement for your continued post-certification employment with Gwinnett County Police Department and your ability to maintain your assignment?
Yes.
So we know that when you fire a semi-automatic handgun, the bullet, gases, particulate matter are expelled out of the front.
Yes.
Is that your experience?
Yes.
In your experience firing a semi-automatic handgun, what happens to the slide?
It goes back.
So it goes back with the same force, or does it go back with the same force that the bullet and the gases and all that go out?
It definitely recoils quite a bit, yes.
Oh, okay, you said recoil. What does recoil mean?
I can better probably just describe it. So when you shoot the gun, there's going to be kind of like a jerk back from all of the gases and everything in the gun. That's why we kind of stand. Well, when they train us, they stand with our legs. We train us to stand with our legs apart to kind of brace for it so we can not like go up from that recoil. They want us to keep the firm arms, bend at the waist a little bit, and to help with the impact of the recoil.
So generally speaking, when you fire a semi-automatic handgun, the bullet goes out and the gun tries to go back.
Yes.
I want to ask you one last question. The defense attorney suggested that there was only Austin's statement, or the defendant's statement, that put him in Yellow River Park. Now, does the digital evidence that you got from his phone records, does that completely and exactly corroborate his statements that he went into Yellow River Park with Tori after turning his phone off and then left in her car and returned home?
I'm just going to object compound. It's like 4 questions in there. I'm just going to object this compound.
It's multiple questions that I'm not sure which one she'll be answering, so please break it down into one question at a time, please.
Does the digital evidence corroborate the defendant's statements?
Yes.
Does the digital evidence corroborate his statement that he was outside Yellow River Park after the time that he left his apartment with Tori?
Yes.
Does it corroborate his statement that he turned his phone off?
Yes.
Does it corroborate the gap in time that he says where the murder occurred?
Yes.
Does it corroborate that he left with Tori's car and went home?
Yes.
Does it corroborate that by showing that he traveled faster than someone could have walked the distance from where his phone started pinging again to his home?
Yes.
No further questions.
So he didn't lie about everything. Right?
At the end, yes.
He couldn't have lied about everything because you got all this corroboration that the prosecutor just pointed out for me. Thank you very much. You have all that corroboration that corroborates what he said, correct?
In regards to his movements after being shown the evidence,
Good.
yes.
But my question was, is there any digital evidence that puts him inside of Yellow River Park?
No, there's not.
There we go. You testified that when the round goes out and when the gun is fired and the gunpowder explodes, that there's recoil or kickback. Is that right?
Yes, sir.
Okay. And are you aware that that's a stovepipe might occur when you have a limp-wristed person holding a gun?
That's possible, yes.
Okay. Have you handled suicide cases as a homicide investigator?
I have.
Okay. And sometimes when someone's committing suicide, they first test fire the gun. Is that your experience?
I have seen cases of this, yes.
There may be a test fire. So a round might be someplace that's super unusual because there's a test fire before the person puts the gun to their head. Is that right?
Yes, sir.
Okay. Detective Smith wrote the statement that Teresa told him Tori was acting irrationally. Is that right?
Yes, I believe so. That was a quote from his.
Okay. And also that Tori took the gun. Is that right?
Yes, sir.
Did you see the recording, if there was a recording between Detective Smith and Teresa Lang?
Yes.
Okay. Do you recall if that was in the recording that Teresa said of Tori Lang she was acting irrationally and she took a gun?
I believe so. It's a long recording, but I believe she does say something of the sort.
Okay, and what I'm trying to understand, you may or may not recall, does Ms. Teresa Lang say that Tori Lang is acting irrationally because she took the gun, or Tori Lang is acting irrationally and she took the gun?
Your Honor, objection. I think he's asking her to interpret a conversation that she wasn't present for.
Judge, the witness has already said she had multiple conversations with the same Teresa Lang. I can start with the question about follow-up if you want me to.
The way I heard the question, he wasn't asking her to interpret, he was asking her what was said on the recording. So if you can clarify that, and then I'll see if Mr. Norris Lewis has any objection.
I'm going to start there. Do you recall on the recording if Ms. Teresa Lang said in regards to Tori Lang she was acting irrationally and she took the gun, she was acting irrationally because she took the gun?
I believe it was and.
And you indicated that when you came onto the case, you spoke to her more than 5 times during the time that you were doing your investigation. Is that right?
Yes, sir.
All right. Did you ever follow up on that portion? Ms. Lang, how was your daughter acting irrationally? Did you ever follow up on that?
We did discuss her behaviors. I don't know if I specifically asked why was she acting irrationally.
Okay.
Yeah.
Okay, and I'm more concerned with the irrational part. Did Ms. Teresa Lang give you some examples of why she thought that Tori Lang was acting irrationally?
Yeah, she did give certain things that stood out to her. Like I said,
you're gonna keep us in suspense. What were the things?
Oh, I didn't know if you were.
It's fine. What were the things that Teresa Lang was explaining to you about Tori in terms of what she perceived as Tori behaving irrationally?
Basic teenage rebellion stuff. She wasn't coming home when she's supposed to. She was going out, hanging out with guys that she wasn't supposed to. Things of the sort. Smoking. They wanted her to stop smoking marijuana. And then she did include in that with her fainting spells and such. So that's a generalization of everything.
Okay. And I understand that language is something fluid. Normal teenage rebellion stuff, in my mind, is rational as opposed to irrational. Does that make sense what I just said?
Yes, sir, it does.
I don't smoke marijuana, but I understand a lot of people like to smoke and enjoy marijuana. Does that make sense?
Yes, sir.
So I don't call that irrational.
Yes, sir.
So I'm trying to understand in terms of what Tori, and it may not be the right word, it's fine, it's fine. What did Tori's mother tell you about irrational behavior? Not normal teenage behavior, not what another 50% of the population might do, irrational behavior. Like jumping out of a moving car. We can agree that's irrational behavior, right?
Yes.
People do it, but we can't think of a good reason as somebody would jump out of a moving car. Did Tori's mother, after saying Tori was behaving in an irrational way, did she give you any irrational examples to support that statement in the many times that you were speaking to her, Tori's mother?
That's a hard question because I think irrational is based on an opinion. Like you just said, in your opinion, something might not be irrational. Like if I was smoking weed in my mom's house, like you said, we might say this normal, but my mom would be like, I'm acting crazy and irrational. So when I talked to her, I don't believe I said the word, why did you say she was acting irrational? I would ask, hey, what was going on with her? What kind of activity did she have going on? What kind of problems did she have? And that's when she went into, she wasn't listening. She wouldn't come home when she was supposed to. She wasn't doing things that I told her to do, so, things like that.
Okay.
Does that answer? I'm sorry. Yeah, okay.
Close enough.
Okay.
Close enough. And you had read Tori's letters that Detective Smith had gathered up?
Yes, I did.
Okay, and those letters indicated that she was sort of experiencing some money troubles, is that right?
Yes.
And the letters, State's Exhibit number 65, those letters had indicated, at least I want to say the third letter, June 1st, 2021, those letters had indicated that Tori was feeling sort of stuck in life, spiritually, emotionally, she was feeling stuck. Do you recall the letters leaving you with that impression?
Yes, that she wanted to do well in life. That's how I read it. And that, yeah, she felt kind of stuck and she was praying to God to help her prosper.
Okay, and the second letter, I call it the second because of the chronology. The second letter from, I think it was May 1st, indicated that she was experiencing just some money trouble. Is that right?
Do you mind if I just look? I just want to make sure this is the correct one. I do remember seeing something of the sort, so I just want to make sure it's this one. She's begging for wealth. Is that what you're...
Yes.
Yeah, she's begging for wealth.
Yeah.
She's asking God for wealth.
And I'm not sure if it's the first one from April 30th or the second one from May 1st. She's talking about people thinking that she was homeless. She was put out of her home. Did you recall reading that in the letters?
Let me look.
I think it's either the first or the second one, halfway down the page.
Yes, my aunt kicked me out.
Oh, aunt. Okay,
Yes.
I couldn't read that word. Aunt kicked me out. She doesn't say mother. She doesn't say grandmother.
She said, let me find it again. I mean, yeah, my aunt kicked me out for a sec. A couple of people thought I was homeless, but I knew I would be okay because in a way I felt you there and you guaranteed me a place to lay my head.
All right, so were you left with the impression from speaking to Tori's mother, Teresa Lang, that Tori was bouncing from family member's house to family member's house?
There was a time where she was living with her aunt, and I did talk to the aunt and grandmother about this as well. So she was doing the same thing, not following the rules, bringing people over, not coming in at the time she was supposed to. So they did tell her to go back to her mother's house.
Okay, and the circumstances under which she had to leave her mother's house, she wasn't listening to her mother's rules.
I don't recall her ever having to leave her mother's house or being told to leave her mother's house.
Okay, well, how did she come to be residing at the aunt's house? Do you know?
I think that was just a choice of hers. No one ever told me that she was kicked out of her mom's house.
I got you. Do you know where the mother lived at in relationship to the grandmother?
Within a couple miles. It wasn't far.
So everybody lived was sort of in the same area, mom, grandma, and auntie. Is that right?
Yes, sir.
I got you.
Auntie lived with grandma.
Auntie lived with grandma. So when she says I was put out of auntie's house, that also meant she was put out of grandma's house. Is that right?
Yes.
That was your understanding?
Yes, sir.
Thank you very much. No further questions, Judge.
Anything further from the state?
Did the defendant lie to you about how Tori was shot?
Yes, based on Dr. Terry's statements, yeah, what he said was not true.
No further questions.
When you say not true, you mean she shot herself and then dropped to the ground. Is that what you're talking about?
Yeah, Austin said that she reached down, grabbed the gun, shot herself, and she fell.
Okay, so that would have meant that she wasn't lying down.
Correct.
Fantastic. The prosecutor asked, is there another possibility where she goes to the park and lays down in the dark and looks up at the sky?
Your Honor, objection, that's outside the scope of redirect.
I'm gonna ask for.
Both of y'all have been outside the scope of redirect, redirect, recross, recross, so I'm going to allow it.
The prosecutor's acting, this is on the issue of I laid down to look at the stars, but I was surprised by getting shot. Where you located Tori, that part of the park is pitch black, correct?
I haven't been there at night, but the surrounding area is black, but I believe you can still see the sky if that's what you're asking.
May be able to see
Yeah.
the sky if you're not under the tree.
Yes.
Where she was found, you can't see any stars or sky because the tree is right overhead. Is that true?
That's a fair statement, yeah.
Right.
Think about it, yeah.
So if we are to understand the prosecutor's new surprise theory, Tori goes to the park, lays down under the tree in pitch black, can see nothing, and is surprised by getting shot. Is that right?
I don't understand your question. I'm sorry.
I'm going to rephrase it. Based on where you found Tori under the tree, could she have seen the stars from that position?
I don't think so.
Okay, was there any blanket or any suggestion that there was a blanket that was laid out at any time so that she could look up at the stars from where she was positioned?
No.
Okay, no further questions.
Anything else from the state?
Is there any physical or digital evidence that tells us exactly what Tori may have thought when she laid down?
No.
Is there any recording, satellite image, digital evidence, physical evidence that tells us what Tori and the defendant may have discussed before she was shot?
No.
No further questions.
Anything else from the defense?
Very briefly, Judge, maybe two questions. You understand that one of the things that Austin Ford is charged with is voluntary manslaughter, is that right?
Yes.
Okay. Is there any evidence whatsoever
In your investigation, that there was a sudden, violent, and irresistible passion resulting from any sort of serious provocation that led to Tori getting shot?
There's no evidence, no.
None. Thank you.
State?
No further questions, Judge.
No questions, Judge.
All right. So, Detective Carter, you may step down now, please. Just take your personal belongings.
Thank you.
Watch your step coming down for me, please. All right, call your next witness, please.
Your Honor, State of Georgia rests.
All right, ladies and gentlemen, the state of Georgia has rested their case. This requires me to take up some brief legal matters with the parties. So we're going to take a mid-morning recess until 10:40. Leave your notepads and pens with you. Remember your precautionary instructions during the break, 10:40. Mr. Adderhold, if I could have you grab those exhibits for me and place them up front, thank you, as well as the prop gun. You can just slap them on top, it's fine. All right, thank you, sir. All right, the state having rested, is there a motion from the defense?
Yes, Judge.
And if you could use that microphone for me, please.
Yes, Judge.
Judge, we have a motion for a directed verdict, and there are, I'm a just outline as best I can, two separate arguments, one theory, two separate arguments. First, as to count 3, voluntary manslaughter, there's absolutely no evidence, and that's the last thing that Detective Carter said. There's absolutely no evidence that Austin Ford was acting solely as the result of a sudden, violent, and irresistible passion resulting from serious provocation. And so we would contend that count 3, there's been no evidence of that. The investigator said that there's no evidence of that. There's no Facebook. There's no anything that would indicate that. And so we would argue, just based on the fact that there's zero evidence of that, that count 3 should be dismissed under directed verdict. As to counts 1, 2, 4, and 5, I think the evidence is pretty clear. Tori Lang is deceased, and the medical examiner has determined that the cause of death is a gunshot wound. Medical examiner has determined that the manner of death is undetermined. The medical examiner, following the physical evidence and the science, cannot determine if it is a suicide or, I'm going to argue, as best as you can summarize the evidence, an assisted suicide, which obviously the court knows is illegal, which is a homicide in Georgia. Her testimony, Dr. Terry's testimony, as I understood it, as summarized in the emails between her and ADA Norris Lewis, her testimony was leaning towards suicide, but she felt compelled to put undetermined because the scene was manipulated. Brittany Barrington testified that the distance of the shell casings is not pertinent. I wrote that down when she said it because it can't be replicated. The rounds fly everywhere out of the ejection port. There's no way to tell how the gun is positioned when the rounds are ejected. The prosecutor then calls the lead detective, who creates a theory for homicide yesterday. I don't know that she was able to maintain it when I put her up here with the gun, the prop, and the baseball. But yesterday she created a theory whose underpinnings were constructed of a shell casing placement. That's how I understood it. Based on the placing of the shell, based on the placement of the shell casings, when law enforcement arrives, she believes the gun had to be held in this way, and that means ultimately if it's a homicide. But before the lead investigator tells the court that, what the court heard, what I suspect the court heard, what I think the jury heard, and what I think is in the record is the prosecutor asking, if this is true and that's true and this is true, then it could be said with certainty that this is a homicide. So if we speculate this and we speculate that and we speculate this other thing, if all those things are true, then this certainly can be a homicide. That speculation, I contend, Judge, is not strong enough, powerful enough to overcome directed verdict, which is why I'm asking the court to grant us a directed verdict on count 1, 2, 4, and 5 based on the evidence. I don't think there is a dispute about the evidence because I don't think there's anything ultimately to refute Dr. Terry, who tells us, I cannot tell. I can't tell. And that's why I would ask for a directed verdict on count 1, 2, 4, and 5, Judge. Thank you very much.
All right, thank you. Who's responding for the state?
I am, Your Honor. With regard to Mr. Lewis's first motion, while there is no direct physical digital evidence that says there was the sudden violent urge to kill, we do know that Tori had the defendant's wallet, that the defendant was very concerned about his wallet and his $300. We know he was searching for a gun for $300 per Detective Carter's testimony, that he was so concerned about it that he called everyone she knew and put out the word, I'm looking for Tori, she's got my wallet, she's got my $3 He then goes to the park with her and turns off his phone. Now he tells...
I'm sorry, who elicited the testimony that he put out text messages that he was looking for his $300?
That's a conclusion, Your Honor. That was not direct testimony. That is a conclusion from the testimony.
From what testimony?
There was testimony that from one of the defendant's interviews that he had been looking for Tori the night she disappeared and that he had called all of her friends, sent text messages to certain people trying to locate Tori. He went to her house on 2 occasions. He checked the mailbox. And based on that testimony, it can be logically concluded that he really wanted his wallet back.
Okay, what about that you just stated makes me take the leap that that is evidence, direct or circumstantial, of a sudden, violent, and irresistible passion resulting from a serious provocation, sufficient to excite such passion in a reasonable person that led to her death?
That alone does not. But when we take into the fact...
in combination with anything.
Well, I haven't... He later goes to the park with Tori. We know that they left together. He said that he never got his wallet back from her, that he turned off his phone as they entered the park. They are in the park, and he left with the gun she had, irrespective of whether or not it was her mother's, and her car. A rational finder of fact could find, in light of all that evidence, that circumstance existed based on everything that was presented. And that is all that is required to overcome a directed verdict.
Okay.
With regard to Mr. Lewis's second argument regarding the other 4 chances, Dr. Terry does not determine whether or not a murder has occurred legally in the state of Georgia. That is left to a jury. That is Georgia law. The fact that she could not determine the cause of death based on the 5 categories that constitute a cause of death in Georgia: accident, natural, suicide, homicide, and undetermined, based on the evidence she had to find undetermined. That alone does not warrant a directed verdict. Period. Ever. There has been evidence It also means that Dr. Terry cannot rule out homicide. So homicide is absolutely not off the table based on Dr. Terry's findings. The evidence before the court, I don't feel the need to rehash. The court has been here and heard the evidence, is more than enough that a rational finder of fact could conclude that this defendant pointed a firearm at Tori Lang's head, that he pulled the trigger, and that he caused her death. That is what is required to overcome a directed verdict in the state of Georgia, whether or not a rational trier of fact could make that finding. Without arguing the strength of the state's case or where Mr. Lewis argues the underpinnings of a theory are, there is enough evidence for a rational trier of fact to convict this defendant. So I ask that each of his motions for directed verdict be denied and that this jury be allowed to decide this case.
All right, I'll give you the final word on your motion, Lawrence Lewis.
Judge, I don't have anything to add. It's been a two-day trial, and I know the court's been paying attention. I don't have anything to add.
All right, the motion for directed verdict as to count 3 voluntary manslaughter is granted by the court. The jury will have no further consideration of count 3 voluntary manslaughter. As to counts 1, 2, 4, and 5, the motion is denied. Those counts will go to the jury for their determination, deliberation, and verdict. With the court's ruling as to count 3, I'll need to go back then and amend the court's draft of the request to charge to strike anything related to count 3 voluntary manslaughter, and I will remove it from the verdict form so that it is not for any further consideration for the jury. Mr. Ford, well, let me ask Mr. Lewis on behalf of Mr. Ford. Is there any need for the court to address Mr. Ford's decision to testify or not testify now that the state has rested?
I don't think there is, Judge, but I'm going to ask the court's indulgence while I ask Mr. Ford 2 or 3 questions or make 2 or 3 points to Mr. Ford. Mr. Ford, the state is rested, and now we're at the point in the trial where ultimately we as the defense would present evidence or not present evidence. Do you understand that? There's no other evidence to present other than you. I don't have any other witnesses on the witness list. There's no other evidence to present but you. So whether or not we present evidence or we just rest without presenting any evidence, that all depends upon your decision to testify or not testify. Do you understand that? I suspect some of it you understand because we've had a prior trial, but I think it needs to be said. You understand if you say, listen, I don't want to testify and I rest, the state is going to have a summary of facts which you cannot address through any testimony after you choose not to testify and we rest. Do you understand that? So this decision to not testify is, I'm going to call it binding for the remainder of this trial. You won't get to, if the jury has a question or anything comes up, hey, I'd like to testify to clarify that. Do you understand that? Okay. Is it your decision to still not testify? Fantastic. Thank you very much, Judge.
All right. Give me just a moment. All right. With that being said, Mr. Lawrence Lewis, when the jury returns, is it your intention to rest at that time?
It is, Judge.
All right. Are both sides prepared then to go directly into closing arguments?
My answer, Judge, is yes with an asterisk, right into as in a minute. I'd prefer not to. I'd prefer about 10 or 15 minutes to swap out those balls and look at my closing once more. I do understand that may put us close to 11 o'clock. I can tell the court, even though Each side has 2 hours for closing. I don't expect my closing to be more than 45, 50 minutes at the most. I just tell the court that so the court can gauge. I don't know if the court would consider severing closings, which it would not be my preference. I would prefer if the state's going to open and conclude that they open, and then I go, and then they conclude, and then we do it that way. Obviously the court may determine that the jury needs a break, but I would prefer that they not open, and then we go to lunch, or they open, and then I do closing, and then we go to lunch. I would prefer that they get all of the closing argument at one time. And I do understand that me taking 10 or 15 minutes is going to...
Please don't take your 10 or 15 minutes giving me your explanation now.
Thank you, Judge.
Okay. So I do not intend to split the closing arguments, but given the hour, I will likely split my charge to the jury with the closing argument. So it may be closing arguments, lunch, come back and charge. Is the state ready?
Yes, sir.
All right. Do you intend to give both an initial and a concluding argument?
Yeah, the state's going to waive over.
All right. Then let's be in recess until 10:55. I'm going to amend the final charge to remove voluntary manslaughter. Everybody be back at 10:55.
Can you make that 11, Judge?
11 o'clock.
Thank you very much. Appreciate that.
11 o'clock. Thank you.
No. I'll do it. Because I got to mark it. Yeah.
Is the state ready for me to bring back the jury?
Yes, Your Honor.
Mr. Lawrence Lewis, are you ready?
Yes,
All right, we're ready for the jury. And each side should have the revised charges and verdict form without voluntary manslaughter. All right, with the state having rested, I'll turn to the defense. Mr. Lawrence Lewis, call your first witness.
Judge, respectfully, the defense on behalf of Austin Ford would rest.
All right, members of the jury, the defense rests as well, which means that the evidence is closed for both sides. The evidence having been closed, I instructed you at the beginning of the trial that once the evidence was closed, the attorneys for each side would have an opportunity to give their closing arguments. The object of closing arguments is for each side to persuade you to decide the case in their favor. I remind you that what the attorneys say in closing argument is not evidence. The evidence comes from the witness stand and from the exhibits that have been admitted. All right, the state has the right to give both an initial and a concluding argument. Does the state wish to give an initial argument?
Your Honor, the state will waive open and reserve the right to conclude.
All right, the state will go last, then we'll hear closing argument from the defense.
Judge.
When I was in high school, my father and I would spend part of my commute to high school together. And, when it was sunny, he would walk, and then when it was raining, he would drive part way before I got on the bus to go up to prep school. And he was always super efficient. So whether we were walking or he was driving, he was always pouring into me, just sharing everything that he could share. And I was just lapping it up, just sort of soaking it up, everything that he was saying when he was talking to me. It was only years later I suspected that he was a little nervous about me going up to the prep school. He really didn't understand anything about prep school, being the son of a sharecropper. Here I am in a predominantly white Catholic prep school, didn't really know anything, but he was trying to share everything that he could share with me about ultimately what he knew. He was an electrician for PATH, Water Authority Trans-Hudson. And most of what we would talk about would revolve around the issues of race and interpersonal communication and interpersonal dynamics. That's what we would talk about. And what he taught me between 1980 and 1984, when we commuted partway together, is before you go to race, before you say somebody's doing something against you because they're black, look at some other things. Maybe they're not that bright, or maybe they've been misinformed, or maybe they just don't like you. Because everybody's not going to like you, and it may not have anything to do with skin color. Talk to me about this all the time, and I was just sort of taking it in. And what I learned is you can hold different perspectives in your mind at the same time. It doesn't always have to be one thing or another thing. You can hold different perspectives in your mind. He was also the first person that sort of taught me that my feelings may deceive me. So I should always rely on facts over feelings. He was the first person to tell me that. He didn't phrase it like that, but when I think back, that's what he taught me, and that lesson has sort of served me well. My oldest son, who's going to turn 22 at the end of the year, he's neurodivergent. I recently figured out that he was ADHD. ADHD is a little bit different than what I thought it was, because what it means is your executive functioning is impaired, and it also means your emotional regulation is also impacted. So when he gets a thought in his head, there's very little logic that's going to shake that thought out of his head. There's no personal history with him that I can refer to that might persuade him. There's no personal adversity that will dissuade him. He may, once he gets that thought in his head, he may see that it's just not going to work out, but he just can't let go of that thought. So that's what he's taught me. So my father taught me to think in different ways, and my son has taught me some people can only see things one way. Stuck is stuck. That's why we asked you to come in here and resolve this issue, because I suspect that you may be able to see the prosecutor is stuck. Homicide, 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 homicide. Now, I don't suggest he's neurodivergent, but clearly he is stuck. There was a total of 17 witnesses called in 2 days, and I'm my father's son. I try to be super efficient. I'm not trying to waste your time. I told you, I didn't want to tell you, it might go till Friday. You're going to have the case today on Thursday. Still may deliberate till Friday. Nobody can determine how long you're going to deliberate, but I don't need to be asking questions of witnesses just to be hearing myself talk, just to be asking questions. That's not even me. You heard from 17 witnesses in 2 days, and you already know it's only about 3. 3 witnesses, that's the whole case. I don't suggest they did anything wrong. They put up what they needed to put up. That's fine. 3 witnesses. Who's the first witness? Dr. Terry, the second one, Brittany Barrington, the third one, investigator Angela Carter. That's the whole case right there. What did Brittany Barrington tell you? State's Exhibit 23. We did the measurements from the head to the shell casings. Fantastic, fantastic. What else did she tell you? Quote, the distance of the shell casings is not pertinent. It's irrelevant. If you fired a gun, what'd she tell you? If you fired a gun, 1 round may go over there by the door, 1 round may go up into the light. That's what she told you. That's what she told you. The placement of the distance of the shell casings, the placement of the shell casings is not pertinent. Now, maybe the prosecutor's going to come up here and he's going to tell you, well, pertinent and relevant aren't the same thing, even though they might be synonyms in the dictionary, because the etymology, maybe he'll do that. You're bright enough to figure that out. We've been doing a lot of weird things in the last 2 days. Maybe he'll get up and do that. Not pertinent, not relevant. The rounds being there, irrelevant. Now, you already know that's irrelevant. You already know it's irrelevant. You didn't even need her to tell you that. Because when we have the head and we have the gun, whether you believe Austin fired the gun or Tori fired the gun is the same distance from the head. So where the rounds land is irrelevant, because the gun is in the exact same position whether Tori shoots herself or Austin shoots her or somebody else shoots her. The gun is 10 to 12 inches, and no. The barrel's parallel. I don't care how you do parallel. The barrel's parallel to the head. So you already know. Whoever pulled the trigger, where the rounds landed, is irrelevant. So I got no clue why the prosecutor trying to dislocate his shoulder up here yesterday, trying to do something crazy. Like it's the OJ case. Are you for real? Listen, you don't need to dislocate your shoulder. It's the same distance. The gun is in the same. The gun doesn't become over here. The gun doesn't. No, everything's exactly the same. The science is exactly the same. We just need to determine who pulled the trigger. So, Brittany Barrington got it exactly right, and you can use your common sense. The distance of the shell casings is not pertinent. Then investigator Angela Carter got here, not today, yesterday. And yesterday, as I'm listening, I thought I heard her say, you write it down. I thought I heard her say, I got together with some other more experienced, since I've only been there 3 weeks, that's fine. That's not a problem. More experienced, more enlightened, that's fine. I got with some other homicide investigators, and we determined, based on where the shell casings were. No, you didn't say that. The shell casings? Back to the shell casings? Let's go with anything but the location of the shell casings. Based on where the shell casings were, the shell casings have nothing to do with nothing. She built a theory by herself or with the other investigators that based on where the shell casings were, it had to be a homicide. What? It had to be. See, because watch this. If it could be a homicide, that's a not guilty. Because the judge is going to tell you after the prosecutor speaks, you got to find my client guilty beyond a reasonable doubt. All these other plausible possibilities, it had to be. Not could be. Could be is not beyond a reasonable doubt, ladies and gentlemen. Had to be. Had to be. So, Investigator Angela Carter said that yesterday, and I was like, well, we're going to have to explore that. And I was like, oh, Judge, Judge was like, no, we're going to end for the day. Oh, I wanted to get at that last night. Today, she sort of backed off that a little bit. She didn't really get with this shell casing theory to prove homicide because you already know. The shell casings cannot tell you anything about homicide or suicide. Can't tell you anything about homicide or suicide. So we get to Dr. Terry. And I love Dr. Terry. Let me just tell you that right now. You love Dr. Terry because she's a doctor. No, I love anybody that works 70 hours a week because I understand people that work 70 hours a week. I understand that means that you probably taking 3 meals on the road. I understand that means a 14-hour day, 5 days a week, or a 12, 13-hour day, 6 days a week. I understand that means that you have to be super efficient on the weekends to get all that dry cleaning and food because by the time you work 8 to 10, everything is closed. If you need to get your hair cut, or you need to get your car serviced, or you need to get your teeth cleaned, you got to fit that in. I love folks that work 65, 70 hours a week. Let me tell you something else about people that work 65, 70 hours a week. They got a low tolerance for foolishness. They got low patience. So when the prosecutor gets, she's acting like this because she's a doctor. No, she's acting like this because she stands alone when she works 70-hour weeks. Are you working 70-hour weeks? She's not going to have any problem with you. But when you work a 45-hour week and you keep asking her the same questions over and over and over and over, she's looking at you, are you insane? 45-hour week people don't question 70-hour week people. That's how it should be. That's not how it is, but that's how it should be. That's what that's about. That's not about her being a doctor. That's not about 6,000 autopsies. That's about stop asking me the same questions over and over and over. Got no problem with you going to the lake house early on Friday. Got no problem with you going to Martini Mondays. Stop asking me the same question over and over and over and over when I'm here devoted to this and you just showing up for your job. Can't wait till 5 o'clock comes. It's because she's a doctor. No. It's because she is a premier medical examiner. Takes extreme pride in what she does. Even on the week, what she do this last weekend? Even on the weekends when she tells you she isn't working, she's working. Even on the weekends when she tells you she's not working. I just went to the office to print something else. 4 hours later. I know that when you're married, your wife tells you, don't call me until you're in the car. Because when you call me from the office and say you're leaving in 10 minutes, you're still there 3 hours later. I love people that work 65, 70, 75 hours a week. I absolutely love them. What's Dr. Terry's job? Dr. Terry's job is science. She's speaking for science. Facts over feelings. That's what she's talking about. Facts, not feelings. What's the cause of death? Gunshot wound. What's the manner of death? Undetermined. What'd she tell you in the email to Norris Lewis? But for the manipulation of the scene, this, in my opinion, is a suicide. but for the manipulation of the scene, but for the gun being removed from the scene, but for this blood trace being on her leg, which you now know is her blood and nobody else's blood, but for the manipulation of the scene, science. I'm just talking for science because I got a brain and vocal cords. Science doesn't have a brain and vocal cords. I'm speaking for science. Science tells us this is a suicide.
She said, I need a volunteer. Well, who's it gonna be? I gotta get on the ground.
That's the way it is, what it is. 70 hours a week. Don't ask other people to do what you're not willing to do. That's how that works. She gets down, and what she demonstrate to us? Well, if it's a homicide and her hands are up like this, then the person has to get down, and because the barrel has to be, won't work, won't barrel. The gun can move any kind of way, but that barrel has to be parallel with the ground for the round to enter the head and go the direction that it did. Slightly up, slightly down. So the person either has to get down here or they got to lay down. And when they lay down, they got to shoot over the arm to hit the person in the head. It doesn't matter how fantastic it is, prosecutor going to stay stuck on what he's stuck on. And then he give you all these other theories. The picnic theory, the midnight picnic theory. That's what we got right before the end, the midnight picnic theory. We went out there for a picnic with no blanket just to look at the stars, and I got surprise shot. Pow! The picnic theory. 1,000,001 theories. But what we're not going to do is we're not going to say, oh, it might be a suicide. Don't say that. Stay stuck on anything that doesn't sound like that. And so I don't really need to talk to you for a long while, because Dr. Terry told you. She's not sure. I told you the original 5 facts. Tori Lang is dead, and there's no question she got shot. And there's no question that my client puts himself there. Those aren't questions. Dr. Terry can't tell you if it's a suicide or a homicide. Dr. Terry has to be able to tell you it's a homicide in order for you to tell Austin Ford he's guilty of murder. Because it doesn't matter how little effort. This was the prosecutor question in voir dire. Well, what would you do? What would you do if somebody told you that they were suicidal? Oh, I would jump off the Empire State Building to save them. I don't know what he expects you to tell them. Some people you're not going to be able to save. I'm going to talk to you, but I don't know if I'm going to be able to save you. Same as a marriage. What you going to do if your wife tells you she's going to divorce you? I'm going to tell her you're an accountant, take 60%, have a nice day. What I'm going to do? What I'm going to tell her? Well, let's go. People are going to make the decisions that they're going to make. And the idea that Austin Ford will be found guilty of murder because he didn't do enough is almost as ridiculous as Austin Ford being found guilty of murder because he lied to the police. Charge him with lying to the police. That's fine. But please don't come up here and say, because Austin Ford lied to the police, you should find him guilty of murder. We're not here on a shoplifting case. We're not here on entering auto. We're here on the most serious thing a person can be charged with, murder. Murder. And then we get into these letters, and we get into some questions about what's going on. And you can see Tori Lang got a little bit of a chaotic life. It's a little bit of chaos. No, I understand none of the family's going to say that it's chaotic. Now, I got that. But it's a little bit of chaos. A little bit unstable financially, boyfriend sort of doing things. He's sort of a boyfriend, he's sort of not a boyfriend. I'm on these diet pills, I'm fainting. I may or may not be taking drugs from Scoop. A little bit of a chaotic life. Mom's saying, listen, can't stay here, you're not following rules. Grandma, auntie putting you out. They love you. And they really loving you now. They really loving you. But it's a little bit of chaos. It's a little bit of chaos. And here's the beauty when you come in this building. This is what I love about the building. If you're going to have a trial where we search for the truth, because that's what trials are about, searching for the truth, you got to tell the truth. You can't tell a half-truth and then say, hey, I'm searching for the truth. You can write on any document that you have in the back, Austin Ford lied, but you can never write guilty on the verdict form because he lied, because Himalayans got nothing to do with the murder. After the prosecutor speaks to you, the judge is going to read the law to you. And, you know, normally I talk to juries about credibility, reasonable doubt. What's reasonable doubt? Reasonable doubt is a doubt of a fair-minded, impartial juror honestly seeking the truth. It's a doubt based upon common sense and reason. It's not a vague or arbitrary doubt, but a doubt for which a reason can be given, like Dr. Terry telling you she can't tell if it's a suicide or a homicide. Based on the conflict in the evidence or gaps in the evidence, the judge is going to tell you the law about reasonable doubt. But the most interesting thing as I'm reading through the jury charges last night is the number of times I see the words facts and evidence, evidence and facts, facts and evidence in the charge that the judge is going to read to you after the prosecutor sits down. The judge is going to read this to you, and you're going to hear the judge repeat certain words throughout the charge of the court. Facts and evidence, facts and evidence, evidence and facts, facts and evidence. You're going to hear those two words over and over and over and over when the judge reads the charge to you. That's because the criminal justice system rests upon facts and evidence, not speculation, not feelings, facts and evidence. So if in fact the thing that's there was a gun, and if this and if that, that's not really how this thing works. Facts and evidence. Towards the end of the jury charge, the judge will specifically tell you the law on the role that feelings are supposed to play. She's going to read it to you. She's going to tell you that you, the jury, are not to show favor or sympathy to one party or the other. It is your duty to consider the facts objectively. That's what she's going to tell you. It is your duty to consider the facts objectively without favor, affection, or sympathy to either party. In deciding the case, you should not be influenced by sympathy or prejudice. Feelings do not play a role here. They're not supposed to. Doesn't mean we don't understand the Langs lost a family member, but in making these decisions, we're supposed to be looking at the facts. At the very beginning of the charge that you're going to hear from the judge is going to tell you it is your responsibility, the jury, to determine the facts of the case from all of the evidence presented. You're not going to hear anything about speculation. You're not going to hear anything about hypotheticals. You're not going to hear anything about musings of the state prosecutor and committees of homicide investigators. You're not going to hear that. The judge is going to tell you your oath requires that you decide this case based on the evidence. Evidence. And then she's going to tell you evidence is the means by which any fact that is put in issue is established or disproved. Evidence, facts, evidence, facts. There's no, how do you bridge that? You bridge that with your feelings. Feelings play no role in this. We want you to use your common sense when you analyze the facts and you put the logic of the law to those facts. The law does not recognize feelings. And when you look at the evidence in the case, the facts in the case, and you put the facts with the law, the question is, has the state met their burden of proving my client's guilt beyond a reasonable doubt? I contend no, obviously. Bare suspicion, the judge is going to tell you, is not enough. And the judge is going to give you an instruction on experts. And did I consent to all their experts? There's only really one expert here. Who's that? You already know. It's Dr. Terry. Dr. Terry's the expert. The judge is going to tell you expert witnesses are those because of their training and experience possess knowledge in a particular field that is not common knowledge. There's an or after that, but I like that part. Because of their training and experience, 70 hours a week, they possess knowledge in a particular field that is not common knowledge. Even to all of the investigators who might work in that field. It's not common knowledge. What she knows is not common knowledge. It doesn't matter that I try 8 homicides this year. I'm not going to have common knowledge. I'm always going to learn something when I talk to Dr. Terry. So what'd she tell you we talk about in the hall? What'd she tell you we talk about? Her vacation. Why? Because I'm normally tired when I see her. I'm on my way to something else, and I'm not asking her about some other case. So we're going to talk about how was your vacation? When are you taking yours? Soon. It might be next never. Listen, we're going to talk about not work. Why? Because her knowledge is not common. And if she's talking, I'm in student mode. Oh, I've been a prosecutor. Doesn't matter how long you've been a prosecutor. Doesn't matter. She's light years away ahead of where you are. How did she get light years? 35 years, 70 hours a week. She's light years away. Do not believe because you know her name and you can call her up that your knowledge is the same. It is not. It is not. So, do you believe Dr. Terry? Dr. Terry can't tell. She prepares a report. She's thinking about it. She's talking to the investigator. She's going back to the report. She's looking at the scene. She's looking at the scene. She's not just coming to a decision willy-nilly. She's struggling with it. Is there a way for me to definitively say suicide or homicide? Suicide or homicide? Can I definitively make that choice? And in the end, she says she cannot. Are you leaning one way or the other? Yes, she makes it clear in the email. I am leaning towards suicide, but because the scene is altered, I cannot rule out homicide. That means it's a homicide. Stuck. Not going to fix that. Not going to fix that. The judge is going to tell you, ultimately, you must believe and determine the credibility of the witnesses. You, the jury, determine the credibility of the witnesses. You can believe 100% of what a person says. You can believe 5% of what a person says. I contend there's only 3 witnesses for you to deal with, but you can believe all of Dr. Terry. You can believe none of Dr. Terry. You can do it. Fortunately for me, I'm in Gwinnett. I'm not in Philadelphia where juries just do wacko things, cuckoo bird things. I suspect you're going to look at the evidence, and I suspect that you're going to respect Dr. Terry's credentials and her experience, and you're going to, as you see, part of your determination of her credibility is you determine her personal credibility. Does she seem like a credible person, irrespective of what she does for a living? Did she appear to try to do everything she could to reach a definitive conclusion? Is she just stuck on suicide and making this thing into suicide? No. She's looking at the science and she's looking at it. Prosecutor asks her a question. There's certain points she has to concede. The science has to concede it. But the science doesn't have to concede ultimately what the prosecutor wants the science to concede. In determining the credibility of the witnesses, the judge is going to tell you that there are certain things that you may consider. One of the things that you can consider is the witnesses' means and opportunity of knowing the facts about which they testify. Knowing the facts about which they testify, how, the distance and the stippling. And does Detective Carter know anything about this? This is not common knowledge. Forget the fact that she's only been there for 3 weeks when this is her first homicide. Forget that. Does she know anything about this? Does she know anything about? So how are you challenging Terry on that? You could talk to Terry about the best salad dressings. Not this. But you, the jury, get to determine. You can consider the witness's means and opportunity of knowing the facts about which they testify. Can Detective Carter tell you anything about homicide versus suicide based on the science? Get real. You may consider the nature and the facts about which they testify. Same thing, the science. You may consider the probability or improbability of their testimony. And I'm okay with with Detective Carter adopting the prosecutor's version of stuff. I'm okay with that. And he can get up here and he can dislocate his shoulder and tell you this is the way it had to be. You already know that's not true because the bullet didn't go to the back of the head to the front. It had to be at the side. But he can get up here and he can twist the gun in the most difficult way. He thinks it's diving. Like, oh, I get more points if the dive is more difficult. No, that's not really what's going on. But he can do it. He can do it. You heard from Dr. Terry. You also get to determine when you're looking at credibility, the interest or lack of interest in the outcome of the case. I don't know if he's going to be bold enough to say Detective Carter doesn't have any interest in the case when she telling the family. Remember I asked her the question, we know you killed her to him. Why are you lying to the family? Why would you lie to the family? All he did was tell lies. Oh, I clearly knew she wasn't suicidal. Why would you tell the family that? Your job as a detective is not to side with the family. You're trying to bring closure to the family, but your job is not to side with them. Dr. Terry's trying to bring closure to the whole case, but she's not siding with the family. So it becomes clear as you listen to Detective Carter's testimony that she's siding with the family. Why? The evidence takes us where the evidence takes us. The facts take us where the facts take us. Don't worry about feelings. It's facts. And ladies and gentlemen, when you take the facts that were presented in this case, specifically the facts and the evidence from the three crucial witnesses in this case, it becomes crystal clear that the only just verdict in this case is not guilty, felony murder, aggravated assault, and the possession of the firearm charges, because no gun is recovered, no gun is ever seen in my client's hands, my client's DNA is not on any gun, there's no gun. What about the gun that he had? Well, we know that's not a P365. The gun that he was arrested with when he was arrested down in Clayton County, when he's bouncing from residence to residence, when he tells the detective, I'm getting a gun because I want to protect my family. Look, on the night that Tori died, he was looking up guns. Sure, because he wants to have a gun to protect his family. That's perfectly understandable. He can't possess a gun because he's under the age of 21, as the detective told us, but that's perfectly understandable. Why would you take that fact that he's looking up guns and said that means he wants to kill? Oh, you stuck on that. Okay. I'm going to ask you to find my client not guilty of all the charges. Thank you.
Thank you, Judge.
All right, thank you. All right, and if you could remove your other...
Sorry, Judge.
Sorry.
All right, then we will hear next the closing argument from the state. Thank you.
I never served in the military, and I don't know firsthand anything about air-to-air combat or how planes defend themselves from missiles. But I do know from my readings over the years that in an airplane, a combat aircraft, one defense that it has against an incoming missile is something called chaff. Chaff is these little bits of reflective material that is designed to confuse the missile's radar and to cause it to explode on the chaff instead of following through to an airplane and to destroy it, which was its target. The truth here is an airplane. What the defense has told you is chaff. With that understanding, some of the conclusions that were just argued to you escape me. How two professionals emailing each other immediately before a trial means that one works all the time and the other is a 45-hour week with no work ethic, just asking random questions, know-it-all. I have no idea how you draw that conclusion because two people participate in an exchange. That exchange happened at a late time. That sample alone, I don't get the conclusion. Allusions to that effect and the volume at which you say something doesn't make it correct. Plain and simple. Speculation, which is now the subject, conjecture, supposition, wild guesses, opinions formed without the basis or with incomplete information, versus facts and evidence. I'm going to tell you exactly what evidence is in the law in the state of Georgia, which will be told by the judge during her charge of the law. But that, Mr. Lewis, doesn't say who gets to question whom. A homicide investigation is a broad and wide thing. It involves a number of parts. It does not involve blind deference to anyone, no matter how educated they are. And it can involve testing a theory. Testing a theory does not mean that you believe that one theory or another is correct or incorrect, but theories get tested. It's part of the process. Things are discussed. Any conclusion you draw from that is just that, a conclusion. It's a supposition. It's speculation. Forget how to operate this thing sometimes. The judge is going to tell you that the state does have the burden to prove every element of this case beyond a reasonable doubt. Now, what every element means is everything: the day, the time, the place. A case cannot be put up just in 3 witnesses, and the other 14 witnesses are not a waste of time. They are the manner in which facts are proven. And the state, beyond a reasonable doubt, has to prove every fact, every single one. Because if I don't have witnesses who say that this happened in Gwinnett County or that Tori was killed in Gwinnett County, then that fact wasn't proven, and a jury can't find someone guilty. So the state has to prove that fact, and it did. Reasonable doubt does not mean beyond all doubt. It does not mean that because one thing might have happened, because there's a possibility, because something is plausible, that is reasonable doubt. It is a doubt in the mind of a fair-minded juror who is honestly seeking the truth. Seeking the truth through all the chaff and all the countermeasures. It's not something that you have to look for. You don't have to engineer it. You don't have to speculate about far-fetched possibilities where guns defy the laws of physics and just ignore recoil. You don't have to do that. If there's a reasonable doubt, there's a reasonable doubt. There's not. Your job as a jury is to seek truth. Now, how are facts proven in a court of law? Facts are proven through evidence. The judge is going to tell you in her charge that evidence is direct and circumstantial. Direct evidence is, I see this pen. This pen is brought into evidence. This pen, like these shell casings, are direct evidence. These shell casings are the shell casings that were recovered from the scene of Tori's murder. The people who touched them, tested them, examined them, looked at them, that is direct evidence regarding these shell casings. Circumstantial evidence is proof of a fact through a set of circumstances. Does somebody see Austin Ford enter Yellow River Park? No. There's no direct evidence of that. Does someone see Austin Ford leave Yellow River Park in Tori's car, traveling from, I'm going to butcher the road or get the road wrong, but from North Deshong Road to his home at the time, at a certain time? No. There's no one who testified that they saw that. But he admitted those things. He admitted he turned off his phone. He admitted that he took the car, and he admitted that he drove to his home. That is corroborated by his Google information that has his cell phone pinging outside of Yellow River Park and then going dark. It has his cell phone moving in a direction from North DeShong Road to his home at a pace that is faster than the average walking pace. So circumstantially, it is proven beyond a reasonable doubt that Austin Ford was in Yellow River Park at the time when Tori was killed. Plain and simple. That is circumstantial. There is absolutely no difference in the law in the weight that you give a direct fact versus a circumstantial fact. A fact is a fact. Now, as I said, the state is required to prove all elements of its case beyond a reasonable doubt. And it has to do so by certain rules that are set out in a very large book or series of books called the Official Code of Georgia Annotated. There are rules about what the jury can be shown, how it has to be shown, how it is proven that the thing is what it's said to be. There are rules that apply to both sides, such as the use of the court's subpoena power to bring witnesses to testify in court. There are some rules that apply to only certain parties or in certain circumstances, and as you saw during the trial, there are objections. That occurs when the state and defense or the parties disagree about the application of a rule or whether or not a question or object or thing complies with those rules. It's just part of the legal process. It happens in, most trials. The judge will tell you that you are the finder of fact. That is your job. The jury's job is to be the finder of fact. You decide who you believe. You decide why you believe them. You decide if they had the opportunity to see what they testified to hear what they testified to, if they know what they're testifying about. You base that on their demeanor, the way in which they testify. What's the manner of their testimony? That's for you to determine. What their motivations are, their interest in the case, and their personal credibility insofar as you observe it, and the probability or improbability of their testimony. You can believe all or part of a witness's testimony because, well, that thing you said here, that I believe, this other thing, not so much. That is your prerogative as the jury. I do want to make a side note about interest in the case and what that means. The state's interest in this case is the finding of truth. That's it. The defense attorney's interest in this case are the interests of Austin Ford. The defense attorney works for Austin Ford. His job is to present the case present his case in such a way that it favors Austin Ford. Period. The charges before you are felony murder, aggravated assault, and 2 counts of firearm during the commission of a felony. Now, what are the facts that we know? So we know from Dr. Terry that the gun was fired from about 12 inches away. 10 to 12 inches was her testimony. That is based on the powder burns and stippling on Tori's head after she shaved the wound. And that's something part of her external examination, which is one part of her autopsy, that was performed July 28, 2021. We know that the wound path was straight across Tori's head. It did not have any upward, downward, or left-right deviation. That essentially is a very fancy way of saying it went straight across. It severed a part of her brainstem, and that would have ceased her motor functions, both voluntary and involuntarily, what she described as almost instantaneously. I believe she said there may have been a breath or two afterwards, but there's no particular way to tell that. Suffice it to say, she would have died from that wound before she would have had the opportunity to voluntarily move anything, which would include dispose of the gun, get rid of her car, or cause the blood transfer that was found on her thighs. Plain and simple, Tori did not do that. She could not have done that. That's not possible. Dr. Terry concluded that she was lying in the position that she was in when she sustained that wound. That was based on her observation of the clothing that Tori was wearing when she was found. There were no drag marks. The particulate on her body, on her clothing, basically was still, as if it was just picked up, not as if she was dragged across it. That's a fact. Where the shell casings were physically located is a fact. Now, there's a whole lot about how they came to be, whether or not they're pertinent. But where they were physically lying is a fact. Circumstantially, Tori could not have been alone. So Tori was not alone. Tori did not move the gun. She did not move her car. Those are facts. Some direct, some circumstantial, but facts nonetheless. The gun was never found. That's a fact. The car was later found on August 1st. The car was found torched in a nature preserve in DeKalb County, literally burned to the frame. That's a fact. The defendant lied for 8 to 9 months to police, to Tori's family, to police, to Tori's family, to police, over and over again. That's a fact. He volunteered nothing during that time. He did not tell Tori's mother that her only daughter was left dead by herself in Yellow River Park overnight. There was contact very early in the morning, maybe 1:30, 2 o'clock in the morning, on July 28th, when Teresa was looking to see where Tori might have been. Austin Ford knew. The defendant knew that he left her by herself, dead, in Yellow River Park, and he just went home after getting rid of the gun, the car, changing his clothes. He even gave the police another person to look at. He brought Scoop up time and time again. Because don't look at me. Don't look at me. I don't want you to look at me. Look over there. Go look over there right now. It's Scoop. Scoop did it. We know that there were 2 shell casings present. No, we do not know how they came to be, where they came to be there. I cannot tell you if they are exactly where they were when they were fired from the gun. I can't tell you that. I cannot tell you if they were kicked. I cannot tell you if they were thrown, picked up, carried, if there were squirrels involved. I can't tell you those things. I know where they were and how many of them there were. Those are facts. I know, and it is a fact, that there were similar markings on the shell casings in where the primer would be, suggesting that they were fired from the same gun. They were the same brand of ammunition. That brand of ammunition could be found in Tori Lang's gun box in the form of live ammunition. Those are facts. Jimenez described for you how a semi-automatic handgun works. That the primer is struck, the bullet and particulate matter and flames and a lot of noise come out of the muzzle of the weapon. The shell casing is ejected from the side. How a semi-automatic handgun works is a fact. The fact that they eject shell casings is a fact. Those shell casings do not, admittedly, travel in any particular direction. They are more likely to throw back and right than they are forward, but I suppose that's possible. Nobody said it didn't. If I stood here and emptied the magazine of a semi-automatic handgun, the shell casings would not land in a neat pile on the floor. They would be kind of in a cone of uncertainty, like the path of a hurricane. Some over there, some over here, some going to go a little further, some going to go a little shorter. That's still a fact. We know what the condition of the ground was. We saw it. It's wet and compact. There's mulch, there's leaves, there's particulates on the ground. It's not a tile or linoleum floor. It is not a smooth, uninterrupted surface. Based on Dr. Terry's physical findings regarding the wound, its path, and how far away the gun was when it was caused, we know the exact position of the gun when it killed Tori. Because Dr. Terry found that she had to be lying right there, that the wound was caused from a gun 10 to 12 inches away. So we know, actually, which is kind of rare, to know exactly where the gun was positioned. What we don't know, based on Dr. Terry's findings alone, is who was holding it, how they activated it. Whether they were laying down, sitting, standing. I can bend over and pretend to shoot it this way, that way. I can get down on the ground, and we're still not going to know, because that's speculation. Assuming that the defendant was standing and bent over, assuming that he was prone on the ground, belly first, with the gun pointed that way, is speculation. Assuming that it had to be Tori and that she activated it with her thumb, with her finger, with a stick, all of that is speculation, because science doesn't tell us that. Science tells us the gun was 10 to 12 inches from her head and what height the barrel was at. It can't tell you where the ejection point was pointing, whether it was pointing straight up in the air. But we can draw some conclusions from certain things. We know from the expert, Kia Jimenez's testimony, that generally speaking, firearms throw up and back, or semi-automatic firearms throw up and back. So if the ejection port was facing up, it is more likely that the shell casing would have gone, in this case, to my left. If it is pointing directly back to the back of the courtroom, it is more likely that the shell casing is going to be on my right, where you can't actually see where I'm pointing. Back here towards the defense table. That doesn't mean that I can tell you that it absolutely was there and the shell casing landed absolutely where it did because of which way the ejection port was. But I know which way they tend to throw, and I know which way it is more likely that that ejection port was facing. So it is, if I've got a shell casing back here, it is more likely the ejection port was facing in this direction than it was in that direction. No, it's not a fact. It's a supposition based on a theory, based on the physical evidence. That's not a wild guess. It's a logical, reasonable conclusion based on the evidence. We know that the blood on Tori's thigh was her own. We also know that it was liquid when it was deposited. Now, why does that matter? Well, much ado was made about a void in the coagulated blood. Now, the photograph that we looked at was a photograph that was taken after Tori was murdered and after she'd been in the park overnight and maybe hour, 2 hours after police had arrived on the scene. Dr. Terry told you that blood, when it comes out of the human body, is in a liquid form, and it takes time to coagulate or clot or solidify. So over time, it got into that state. In that photograph, that blood had 6-7 hours to become the state that it was in. It was not in that state when Tori was killed. It had to be in the liquid state because that's how blood works. I don't suggest anybody go back in the jury room and cut yourself just to prove that particular theory. We know that the only thing Tori had in her system was phentermine, which is a drug that's prescribed for weight loss. It's a stimulant, and there was no testimony that it would cause hallucinations or any kind of wild behavior. We know that the defendant turned his phone off on the way into Yellow River Park. We know that because he told us, and the records corroborate that. Now, the reason that he gave is not corroborated, and is not a fact, which is that he turned it off because he was scared. That doesn't make any sense under any set of circumstances. Scared is an emotion. It can lead you to freeze. It can lead you to panic. It can lead you to act. But to turn off your cell phone? Turn off, I'm scared, so I'm going to turn off my cell phone. According to his statements, my friend has a gun and is driving me some unknown place, and I'm scared. So I'm going to turn off my cell phone. And we know, and it is a fact, that he lied about, concealed, evaded, and hid his knowledge about Tori's death from everyone around him, everyone he knew, and everyone who contacted him. Tori's mother, the police, period. Went to a funeral knowing that he'd left her dead in the dark by herself in Yellow River Park. Did not tell her mother, did not call the police and say, my friend, she took the gun, she killed herself. That's not, he didn't say that, because that's not what happened. Now, what is speculation? As I said, that's an opinion that is formed on the basis of incomplete information or in the absence of information. Whether or not a stovepipe occurred. There is literally no physical evidence that a weapon stovepiped or that it was cleared anywhere on that scene. That's a wild guess as to how something may have happened based on exactly nothing. What object may have laid in blood at one point or another? We know that there was blood on the ground. We observed a spot of coagulated blood and a spot where there was no blood coagulated. It is speculation to say that there was an object there, that there was another object there. We see, and I'll show you shortly, we see that the ground is not solid. Blood may absorb into the ground in different places. It may deposit on other objects. It does not exclude the intervention of wildlife or small animals, rabbits, squirrels, anything that may be alive in the park. We know that Tori was alone from about 11:46 until 6:30 in the morning. None of those things can be excluded. So to say and go up to the screen and say, oh, the gun must have been this way, and look at this. speculation based on the way you want the evidence to be for your client. It is a fact that the defendant left with Tori. It is a fact that he left again that same night after Tori had been murdered and was wearing pants instead of white shorts. It is a fact that he returned later on, now early into the next morning, now wearing a different top. Those are facts. Now, this is the photograph that's largely in question. Now, this illustrates several things. This is the wound on Tori's head. That was caused by a firearm 10 to 12 inches away because of those little marks are particulate matter from the weapon that killed Tori. We all know why. I don't have to reiterate that again, and why it was the distance that it was. What is in dispute, or what is not known, is what, if anything, caused there to be blood coagulated here, but not here. We see sticks, mulch, it's a leaf right there, a leaf partially buried right there. If you look at, in the corner near Tori's elbow, this is not smooth ground. I'm not even sure it's dirt. It might be mulch. But there's clearly blood absorbed into the ground in some place. That's also a fact. That looks to be part of an acorn. There are other things on the ground. And to sit here and say that it had to be a gun, and it had to be this way or that way, that's speculation based on the way someone wants you to think about what evidence there actually is. But that's all it is, speculation. I know there is blood coagulated in one spot and not in another. What I do not know and what is not a fact is why or how. We know this ground was compact. We see debris of some kind all over it. There's sticks, there are small patches of growth, mulch or whatever this is. That appears to be dirt. There are plants near the base of the tree. We know the ground was in such a condition that even though by this time there had been multiple police on the scene, EMS, that nobody was leaving footprints. That's a fact. That's something that we know. Dr. Terry has encountered 10,000 or examined around 10,000 bodies as a medical examiner. She has taught medical examiners. She has taught her end of death investigation to police. There is no question that Dr. Terry is an expert in her field. That field is forensic pathology. Period. She is an expert in her field. There's no question of that. Over that time, she has seen exactly one distant suicide where the thumb was used to fire a weapon. And that is the most plausible way in which Tori could have killed herself. That would have had to be to make that shot across the back of her head, straight up, not left or right, at a distance, would be with her thumb. That's exactly 1 in 10,000, and I believe, and the jury will recall if I'm right, that was actually a case study and not one that she directly examined herself. If it was one that she examined herself, and I'm mistaken about it being a case study, then that is 1 in 10,000, or 0.0001% of all the bodies she examined would have been a suicide in the manner in which the defendant claims that Tori committed suicide. Well, his lawyer does. Not the way he did, because that's different. Dr. Terry absolutely is qualified and is an expert and can determine that Tori sustained a fatal gunshot wound. What the path of that wound was, that her death was almost instantaneous, that there was no movement after her brainstem was severed, what position she was in after her death, and that she was not significantly moved or dragged after she was murdered. Her finding was made, I believe, finalized August 17th or thereabout in 2021. A lot of things happened between August 17th of 2021 and now, and the time when Austin Ford was charged with Tori's murder. The car was found. Officers interviewed, spoke to Austin Ford repeatedly. The records from the defendant's cell phone and Gmail account were obtained by Detective Carter. None of that was known, or the results of that weren't known, August 17th, 2021. Because Dr. Terry fulfilled her role in a homicide investigation. What does the scene and body tell us about how this person died, and what determination can be made? And I will concede to you, based on the physical evidence alone, and I'm going to stress alone, it can't be determined how Tori was killed, based on the physical evidence alone. But we have so much more than that. It is not, Dr. Terry is not a homicide investigator. She's not employed directly by the Gwinnett County Police Department. She is the medical examiner for Gwinnett County. She does her job, she fulfills her role, and she does so admirably. She is absolutely one of the hardest working people I know. I don't expect to necessarily get emails from the medical examiner at 8:55 at night, nor do I expect to respond to them, but when I get them, I do. Dr. Terry did. Her official manner of death was undetermined. So now we look at everything else. We got this part. Now let's look at the other parts. We know there were no other significant areas of blood. We know the ground was the condition that it was in. There's one blood spot on the ground, various types of dirt. Debris from the trees, sticks, leaves, mulch, whatever washed up the last time it rained, all that. So we consider whether or not Tori committed suicide, because Dr. Terry can't rule it out, nor can she find it to be the cause of death. Because if she could find it to be suicide, she would have ruled that it was suicide. If she could find it to be homicide, she'd rule it was homicide. So the suicidal narrative comes primarily and is repeated primarily by the defendant. While Tori's mother may have been concerned that she hurt herself and that she took her gun, we're talking about a woman who has just been informed that her beloved only child is dead in Yellow River Park and that her gun is missing. She doesn't know anything at this point other than those facts. So wild speculation on her part, emotional speculation on her part, can be expected. You're going to run through everything. You've just lost your child. There is exactly no evidence, none, that Tori asked anybody else to hurt her. The only person you hear that from is from the defendant. We look at the distance the gun was and the things that we know, and that the shot came while Tori was lying down, and that it came in the dark while she was staring towards the sky. And it doesn't matter if she was looking at the leaves, the stars. She was looking up. Science or nothing else can tell you what was in somebody's mind. I have no idea why Tori laid down. There is no evidence to explain why Tori laid down. There is no evidence that explains why Tori was looking up, what she hoped to see. Or maybe it was just looking up into the darkness in a moment of peace. Don't know. It's not a fact. It's speculation. To sit here and say, oh, it's a picnic and she couldn't see the stars and it was a picnic, that's speculation based on nothing. It's speculation designed only to serve the defendant. And when we consider what the defendant ultimately said in his interview with Detective Carter, why, if you're coming clean, why do you keep lying? Why do you still lie? Why is it you say she grabbed the gun off the ground and just shot herself in the head? That's what he says. While she was standing up, she fell straight back and somehow her braids magically just came out from under her head. It's ridiculous. Because he's still lying. He had to admit he was there because his cell phone says he was there. He had to admit he took her car because his cell phone says he was in a car. He told you he got rid of the gun in a pond by his house. A pond. By his house. That's what you do when your friend commits suicide. You throw the gun in the pond, right? Suicide looking way less likely, isn't it? The defendant is the one who tells us that he killed Tori. Does it say, I killed Tori? No. But his actions speak way louder than the words he told Detective Carter do. He didn't admit he was in Yellow River Park until she told him the cell phone put him there. He didn't mention getting rid of the gun or what happened to it until we knew he was there with Tori when she was murdered. He didn't mention the car until he had to. He paints himself with Detective Carter as this helpful, loving, caring friend who I was so concerned with her. I took the gun from her and I hugged her and she just pushed me away, grabbed the gun off the ground and shot herself in the head. Ridiculous. We know it's all a lie. We know it's a lie because he's been lying from the beginning. The only truth in what he said are the things that are proven by the facts we know. Everything else, everything that points to him being guilty of the murder he's guilty of, he lies about. Concedes what he has to and keeps lying. This is the cover-up of a murder. Period. End of discussion. What do you do when you've murdered someone? Well, you get rid of the gun. I can't have the gun found. The gun might point at me. It might have my fingerprints, my DNA. Got to get rid of it. They find the gun on me, they're going to know I did it. So I get rid of it. So I dump it in the lake. I got to get rid of the car. Well, the car was here. It's the scene of murder. It's got my DNA. Oh my God, I got blood in the car. I got to get rid of the car. The car's got to go. Well, what if the police ask me about it? Because they're going to find her shot. Well, I can't tell them the truth. I can't tell them I was there. I'm sure not going to tell them I murdered her. So I'm going to give the police someone else to look at. Yeah. Who? Scoop's a bad guy. He's got tattoos on his face. He hits scams, does drugs. Scoop did it. Wait, oh crap, I'm wearing clothes. Oh man, these shorts are white. Oh, I got blood on them too. I gotta get rid of the shorts. Well, oh man, there's blood on the sleeve of my hoodie. I gotta get rid of it too. You know what? I'm gonna try and act normal. I'm gonna act like this didn't happen. You know, what would a friend do when their friend is dead? Oh, well, I gotta call her mom. I'll talk to her mom. I'll go to the funeral. I'll do all the things. Ooh, go back to the scene. Back to where I killed her. I don't know about that. I know my best friend just died, but I gotta go play football. You admit what you have to. They got a fact over there. I gotta concede that. Okay, yeah, fine. I was there. I turned my phone off. The car and the movement. Oh, well, okay, I took the car. Why did I do that? Oh, she told me to. Yeah. She told me to. He says that she's got this plan that involves him disposing of the gun in the car. But he also says that it was some impulsive thing where she grabbed the gun off the ground. Hallmark of a lie, maybe? The car turns up in a field in DeKalb County, burnt to the frame. The nature preserve in DeKalb County, burnt to the frame. And the gun may or may not be at the bottom of a pond or a lake, remarkably down the street from his house. This is the product of conscious, rational, deliberate thought. It's the cover-up of a murder. You know it was there. He tells us, his cell phone tells us, and then he covers up a murder. This is now where you come in. You, the jury, the finder of fact. Seek truth using the whole investigation. Do not fixate on one of those little reflective floaty things in the air, explode, and stop seeking the truth claim. Every witness plays a part. Every witness has a small part in the investigation of a homicide. The thing about people is we all have different skill sets. One person may be an expert at forensic pathology. Another person may know everything there is to know about handguns for firing thousands upon thousands of them. One person may be trained to take all of this information and consolidate it and come to a conclusion. Every one of these witnesses knows something different, has a different background, a different education, a different skill set. You, the jury, who are actually kind of configured the same way, where you have people of different ages, different backgrounds, different skill set, different experiences, get all of these things. You get Casey Smith, who, yes, you know what? Casey Smith, or Casey Crisby now. Casey was a patrol officer for a couple of years, and she left and decided to do something else. But she was trained in how to rope off the scene, to make the observations, and call the people she needed to call. Sergeant Smith was the initial, and never were related as far as I know, the initial investigator. He played his role. He started the process of getting geofences and trying to narrow down who might have done this to Tori. But the case was reassigned to Detective Carver, who, although a new investigator at the time, certainly can't be discounted or pushed to the side because this may or may not have been her first homicide case. The facts that she discovered remain facts. Tanya and Teresa Lang knew Tori far better than anyone around her. They, unlike us, had the privilege of knowing Tori. None of the other witnesses knew Tori while she was alive. None of the witnesses, including Tanya and Teresa, told you that Tori was suicidal, that she was hell-bent on ending her own life, nor does a single word in any of the letters that she wrote to God. She prayed for wealth. She prayed for solutions to her problems that are common, like needing more money. There is nothing beyond the pale or out of the ordinary that's not the experience of the average 18-year-old girl. There's nothing to indicate that she would have come up with this elaborate, ridiculous plan to end her life and then, on some spontaneous urge, grab a gun off the ground, shoot herself from 10 to 12 inches away, while her best friend carries off the gun and the car and pretends it never happened. Because that's ridiculous. It's far-fetched. When you start looking at the 0.00001%, it starts getting a little further away, doesn't it? Mary Boone Perkins, the only thing, she happened to have a ring camera, pure coincidence. Dr. Terry, the two young ladies from the crime lab, and of course the entire Gwinnett County CSI team, Brittany Barrington, Kia Jimenez, and Abigail Hamill. Every fact that they uncovered and every piece of information that they gave you is part of the picture. The defendant's attorney just keeps saying Brittany Barrington because she said the shell casings weren't pertinent. Well, what that means is that she can't tell you how those shell casings came to rest 9 and 14 feet away from Tori's head. No one can. No one can tell you what happened to them from the time that they were fired until the time that they were found. That's just where they were. We know that. That's true. What it doesn't mean is that when looking at all the other evidence and trying to come to a reasonable conclusion that, we're going to try it on this side now, that when the ejection port of a weapon is facing to my right, that the shell casing being in that direction 9 feet isn't consistent with it, because it still is. Now, does that mean that that's the underpinning of the theory? No. It's consistent with that theory. Everything else, the distance, the height of the gun, that's known. Where the ejection port isn't known by a fact. But that shell casing being there is consistent with this. And just as there is no evidence to show exactly how it landed there, there's no evidence to show that it was in fact moved there. When you look at everything, you don't come to the conclusion that Tori committed suicide. Tori could not have held the gun in such a way that shell casing landed there. The defendant could and did. Whether it was what the defense attorney is calling assisted suicide or a straight-up murder, his hand was on that gun when it was pointed at Tori's head. His hand pulled the trigger. I can't tell you that Tori knew or didn't know it was going to happen. There's a lot we don't know, a lot the evidence doesn't show, but we have to look at what the evidence does show. The last thing that I don't want you to go in that room with is the memory of Tori Lang lying alone in Yellow River Park, murdered by the defendant. Ladies and gentlemen, 0.001% is not reasonable doubt. The only reasonable conclusion, based on the facts and evidence, not on blind speculation designed to help this defendant, is that he is guilty of aggravated assault, felony murder, and 2 counts of firearm during the commission of a felony. I ask you to go back in that room and find exactly that. Thank you, Your Honor.
All right, given the hours at this time, I'm going to ask Bailiff Wooten to keep all the jurors together for lunch. The court is going to pick up your lunch together in the cafeteria. I remind you of your precautionary instructions at lunch. Do not discuss the case with anyone, including amongst yourselves. Do not let anyone discuss the case within your presence or hearing. Let's be in recess for lunch until 1:15. Keep everyone together, pick up their lunch. At 1:15, we will reassemble so that I can instruct the jury on the law and turn the case over to them to begin their deliberations. Leave your notepads and pens in the chair, please. All right. I would like, before we recess for lunch, if we can agree on the exhibits that are going to go out.
That's fine, Judge. I gotta mark this anyway. I think we agreed to mark it 3A
A, B.
3A. That's fine, Judge. I'll mark for cut A.
I can't specifically remember which you labeled A and B, but thank you.
If you'll start organizing the exhibits so that you and Mr. Lewis can look and agree on what goes out, and we can place that on the record, please. I do.
Is your thought to send back the zips or leave
I
it?
don't believe we send the zip drives
That's
back
fine.
typically, and there wouldn't be any method by which they could activate or actuate any data on it anyway. That goes back.
Yes.
The gun is much evidently it does.
All right, when you have them separated, I just need one person to speak on the record as to what goes back.
Mr. Lewis. Your Honor.
That's what I was trying to clarify, but thank you, Madam Court Reporter.
1, 2, 4. Oh, sorry.
What do you think about the letters?
I think the legs go back.
I don't think your testimonial side.
That's right.
I would
Agree.
agree. Those are all otherwise, those do go back. These were admitted for record purposes, even though just admitted, I do not believe the search warrants and letters of authentication go back. Yeah,
All right, so if the list of what does not go back is shorter, I'd ask that we place on the record what the agreement is as to what does not go back.
Your Honor, the agreement is that States Exhibit 31 states 7 in its entirety, 20 in its entirety, 6 in its entirety, 30, 61, 64, 71, and 70. States 66, 67, 68, 69, 62, 63. Defendants 1, 2, 3 in its entirety, and 4 do not go back with the jury.
All right, all other exhibits you agree go out?
We do, Your Honor.
Is that correct for the defense as well?
The short answer is yes. I need to just double check the law and demonstrative evidence, but for now, the answer is yes. I think the jury does have the right to demonstrative evidence, but I'm not going to argue about that without checking out the law. I'll check out some law, Judge, and then we'll have another discussion about that later.
All right, for now, the items that you agree do not go back. If you'll place those with the court reporter, she'll maintain possession of what does not go back.
Oh, sorry. I was going to move this to the witness stand for the bailiffs. That's what does go back.
All right, anything else from the state before we recess for lunch until 1:15?
No, Your Honor.
Anything from the defense before we recess until 1:15? All right, please be back at 1:15 so that I can charge the jury.
Yes, Your Honor.
Thank you. We're in recess. Not sure if all of the jurors are back up yet. Everyone, please check your cell phones to make sure they are powered off.
We could do that later.
Don't put the charges in there, just all those copies. All right, for those of you who just came in, please check your cell phones. They must be powered all the way off, not just on silent. We're ready. All right, sir, if you leave, you're not going to be able to come back in once I start speaking with the jury. Okay? All right, thank you. Mr. Adderhold, no one is permitted to enter or leave the courtroom as I'm charging the jury, please. All right, welcome back from lunch, ladies and gentlemen. The evidence now being closed and the attorneys having had an opportunity to provide their closing arguments, I will now instruct you on the law. This is rather lengthy, but I'm going to send out individual written copies of everything that I tell you, so you will have that with you in the jury deliberation room. So you don't have to feel the need to take notes while I'm giving you these instructions. All right, members of the jury, you are considering the case of the state of Georgia versus Austin Tybre Ford. The district attorney has indicted the defendant for the offenses of felony murder, aggravated assault, and possession of firearm during commission of felony, 2 counts. Count 3, voluntary manslaughter, has been removed from any further consideration by you. The indictment has previously been read to you. To the indictment, the defendant has entered a plea of not guilty. The indictment and the plea form the issue that you are to decide. Neither the indictment nor the plea of not guilty should be considered as evidence. This defendant is presumed to be innocent until proven guilty. He enters upon the trial of the case with a presumption of innocence in his favor. This presumption remains with him until it is overcome by the state with evidence that is sufficient to convince you, beyond a reasonable doubt, that the defendant is guilty of the offenses charged. No person shall be convicted of any crime unless and until each element of the crime is proven beyond a reasonable doubt. The burden of proof rests upon the state to prove every material allegation of the indictment and every essential element of the crime charged beyond a reasonable doubt. There is no burden of proof upon the defendant whatsoever, and the burden never shifts to the defendant to introduce evidence or to prove innocence. When a defense is raised by the evidence, the burden is on the state to negate or disprove it beyond a reasonable doubt. However, the state is not required to prove the guilt of the accused beyond all doubt or to a mathematical certainty. A reasonable doubt means just what it says. It is a doubt of a fair-minded, impartial juror honestly seeking the truth. A reasonable doubt is a doubt based upon common sense and reason. It does not mean a vague or arbitrary doubt, but is a doubt for which a reason can be given, arising from a consideration of the evidence, a lack of evidence, or a conflict in the evidence. After considering all of the facts and circumstances of this case, if your minds are wavering, unsettled, or unsatisfied, then that is a doubt of the law, and you must acquit this defendant. But if that doubt does not exist in your minds as to the guilt of the accused, then you would be authorized to convict him. If the state fails to prove the defendant's guilt beyond a reasonable doubt, it would be your duty to acquit the defendant. Facts and circumstances that merely place upon the defendant a grave suspicion of the crime charged, or that merely raise a speculation or conjecture of the defendant's guilt, are not sufficient to authorize a conviction of the defendant. It is my duty and responsibility to determine the law that applies to this case and to instruct you on that law. You are bound by these instructions. It is your responsibility to determine the facts of the case from the evidence presented. You must then apply the law that I am giving you to the facts as you find them to be. Your oath requires that you will decide this case based on the evidence. Evidence is the means by which any fact that is put in issue is established or disproved. It includes the testimony of the witnesses and any exhibits admitted during the trial. It does not include the indictment, the plea of not guilty, opening or closing remarks of the attorneys, or questions asked by the attorneys. Evidence may be either direct or circumstantial or both. In considering the evidence, you may use reasoning and common sense to make deductions and to reach conclusions. You should not be concerned about whether the evidence is direct or circumstantial. Direct evidence is the testimony of a person who asserts that he or she has actual knowledge of a fact, such as an eyewitness. Circumstantial evidence is proof of a set of facts and circumstances that tend to prove or disprove another fact by inference, that is, by consistency with such fact or elimination of other facts. There is no legal difference in the weight that you may give to either direct or circumstantial evidence. You would be authorized to convict only if the evidence, whether direct, circumstantial, or both, excludes all reasonable theories of innocence and proves the guilt of the accused beyond a reasonable doubt. You as the jury must determine the credibility of the witnesses. In deciding this, you may consider all the facts and circumstances of the case, including the witness's manner of testifying, their means and opportunity of knowing the facts about which they testify, the nature of the facts about which they testify, the probability or improbability of their testimony, their interest or lack of interest in the outcome of the case, and their personal credibility as you observe it. Now, testimony has been given in this case by certain witnesses who are termed experts. Expert witnesses are those who, because of their training and experience, possess knowledge in a particular field that is not common knowledge or known to the average citizen. The law permits expert witnesses to give their opinions based upon their training and experience. You are not required to accept the testimony of any witness, expert or otherwise. The testimony of an expert, like that of all witnesses, is to be given only such weight and credit as you think it is properly entitled to receive. To impeach a witness is to show that the witness is unworthy of belief. A witness may be impeached by disproving the facts to which the witness testified. Your assessment of a trial witness's credibility may also be affected by comparing or contrasting that testimony to statements or testimony of the same witness made before the trial started. It is for you to decide whether there is a reasonable explanation for any inconsistency in a witness's pretrial statements and testimony when compared to the same witness's trial testimony. As with all issues of witness credibility, you, the jury, must apply common sense and reason to decide what testimony you believe or do not believe. The testimony of a single witness, if believed, is sufficient to establish a fact. Generally, there is no legal requirement of corroboration of a witness, provided you find the evidence to be sufficient. The defendant in a criminal case may take the stand and testify and be examined and cross-examined just as any other witness. You should evaluate such testimony as you would that of any other witness. However, the defendant does not have to present any evidence nor testify. If the defendant chooses not to testify, you may not consider that in any way in making your decision. A statement that the defendant allegedly made while in custody has been offered for your consideration. Before you may consider this as evidence for any purpose, you must determine whether the defendant's statement was voluntary, and if the statement was given in custody, whether the defendant was properly advised of his constitutional rights. To be voluntary, a statement must be freely and willingly given and without coercion, duress, threats, use of violence, fear of injury, or any suggestions or promises of leniency or reward. A statement induced by the slightest hope of benefit or the remotest fear of injury is not voluntary. To be voluntary, a statement must be the product of free will and not under compulsion or any necessity imposed by others. In determining voluntariness, you may also consider to what extent the defendant was informed of his rights. You may consider the duration and conditions of detention as factors relevant to the question of whether or not a statement was freely and voluntarily made. The burden of proof is upon the state to establish that the statement was voluntary, that is, freely and willingly made. If you do not find that the statement was voluntary, you may not consider it for any purpose. If you find that the statement was made while in custody and as a result of police questioning, you must also determine whether the defendant was advised of his constitutional rights and whether the defendant clearly understood and knowingly gave up such rights. The constitutional rights that law enforcement officers must explain and that the defendant must understand and voluntarily give up before any custodial statement is taken by law enforcement are as follows. 1, the defendant had a right to remain silent. 2, if the defendant chose not to remain silent, anything he said, wrote, and signed could be used as evidence against the defendant in court. 3, the defendant had a right to consult a lawyer before any questioning and to have the lawyer present with him at all times during any questions. And 4, if the defendant did not have money for a lawyer would have been provided for him to represent him before any questioning and to be present with him during any questioning. If the defendant exercises any of these rights, such as requesting an attorney, the police cannot question the defendant any further without an attorney being present. If the police initiate or continue conversation with the defendant after the defendant exercises such right, then any statement made to the police by the defendant after he exercises such right would not be voluntary, and you must disregard it entirely and completely in reaching your verdict in this case. However, if the defendant solely on his own initiative, after exercising such rights freely and voluntarily, requests and initiates further conversation with the police without an attorney and without any request, instigation, coercion, duress, fear, or hope of benefit or reward, or other action on the part of the police, then you would be authorized to consider the statement, provided you find from the evidence and the court's instructions that any such conversation or statement was otherwise freely and voluntarily given by the defendant. The burden of proof is upon the state to establish that the warnings of all rights mentioned were given, that they were understood and knowingly given up by this defendant. If you find that the defendant's statement was voluntary and that all the warnings as to his constitutional rights were given, that he understood the meaning of what was said and knowingly gave up such rights, then you may consider it as evidence. If so, then you must apply the general rules for testing the believability of witnesses and decide what weight, if any, you will give to all or any part of such evidence. If you fail to find that the defendant was properly informed of these rights and that he understood and gave up these rights, you must disregard the statement entirely and give it no consideration in reaching your verdict. You should consider with great care and caution the evidence of any out-of-court statement allegedly made by the defendant and offered by the state. The jury may believe any such statement in whole or in part, believing that which you find to be true and rejecting that which you find to be untrue. You alone have the duty to apply the general rules for testing the believability of witnesses and to decide what evidence should be given to all or any part of such evidence. A defendant's out-of-court statement that is not supported by any other evidence is not sufficient to justify a conviction, even if you believe the unsupported statement. However, proof by other evidence beyond a reasonable doubt that the crimes alleged have been committed may constitute supporting evidence of a defendant's statement, if any, should you so find. The law does not fix the amount of supporting evidence necessary. You must determine whether or not other evidence sufficiently supports a defendant's statement so as to justify a conviction. If you find that there was a statement made by the defendant that was supported by other evidence, the degree of proof necessary to convict is that you be satisfied of his guilt beyond a reasonable doubt. During the trial, you viewed and heard audio and video recordings of interviews purportedly between the defendant and the police. You saw and heard the interviewing officers make certain statements to the defendant. You are instructed again that the declarations or statements of the officers are not evidence, and you should not consider such as evidence unless those statements are proven to you by other competent evidence. Identity is a question of fact for you to determine. Your determination of identity is dependent upon the credibility of the witnesses offered for this purpose. You should consider all of the factors previously charged regarding credibility of witnesses. Some, but not all of the factors you may consider in assessing reliability of identification are as follows. The opportunity of the witness to view the alleged perpetrator at the time of the alleged incident, the witness's degree of attention towards the alleged perpetrator at the time of the alleged incident, the possibility of mistaken identity, whether the witness's identification may have been influenced by factors other than the view the witness claimed to have, whether the witness on any prior occasion did not identify the defendant in this case as the alleged perpetrator, and the length of time between the crime and the out-of-court identification. It is for you to say whether under the evidence in this case, the testimony of the witnesses, and the facts and circumstances of the case sufficiently identify this defendant beyond a reasonable doubt as the perpetrator of the alleged crime. It is not necessary that the defendant show that another person committed the alleged offense. If you do not believe that the defendant has been sufficiently identified as the person who committed the alleged crime, or if you have any reasonable doubt about such, then it would be your duty to acquit the defendant. The burden of proof rests upon the state to prove, beyond a reasonable doubt, the identity of this defendant as the person who committed the crime alleged in the indictment. Evidence relating to DNA comparison has been admitted for your consideration. Identification by DNA comparison is considered opinion evidence and is governed by the law concerning opinion testimony as has been given to you. As opinion testimony, evidence relating to DNA comparison is dependent upon many factors. Among the factors are the credibility and accuracy of the witnesses who were involved with the process of obtaining, identifying, preserving, recording, and maintaining the physical evidence, and upon the accuracy and validity of the testing procedures themselves that were used to form those opinions. All of these issues are matters for you to consider and determine. It is for you to determine what weight, if any, you will give to the evidence relating to DNA comparison in your decision in this case. This defendant is charged with crimes against the laws of this state. A crime is a violation of a statute of this state in which there is a joint operation of an act or omission to act and intention. Intent is an essential element of any crime and must be proved by the state beyond a reasonable doubt. Intent may be shown in many ways, provided you, the jury, believe that it existed from the proven facts before you. Intent may be inferred from the proven circumstances or by acts and conduct, or it may be on your discretion inferred when it is the natural and necessary consequence of the act. Whether or not you draw such an inference is a matter solely within your discretion. Criminal intent does not mean an intention to violate the law or to violate a penal statute, but simply means the intention to commit the act that is prohibited by a statute. This defendant will not be presumed to have acted with criminal intent, but you may find such intention or the absence of it upon a consideration of words, conduct, demeanor, motive, and other circumstances connected with the act for which the accused is being prosecuted. Every person is presumed to be of sound mind and discretion, but this presumption may be rebutted. You may infer, if you wish to do so, that the acts of a person of sound mind and discretion are the product of that person's will, and a person of sound mind and discretion intends the natural and probable consequences of those acts. Whether or not you make any such inference or inferences is a matter solely within your discretion. Knowledge on the part of the defendant that the crimes of felony murder, aggravated assault, and possession of firearm during commission of felony were being committed, and that the defendant knowingly and intentionally participated in or helped in the commission of such crimes must be proved by the state beyond a reasonable doubt. If you find from the evidence that the defendant had no knowledge that a crime was being committed, or that the defendant did not knowingly and intentionally commit, participate, or help in the commission of the alleged offenses, then it would be your duty to acquit the defendant. On the other hand, should you find beyond a reasonable doubt that the defendant had knowledge that the crimes of felony murder, aggravated assault, and possession of firearm during commission of felony were being committed, and that he knowingly and intentionally participated or helped in the commission of it, then you would be authorized to convict the defendant. A jury is not authorized to find a person who is merely present at the scene of the commission of a crime at the time of its perpetration guilty of consent in and concurrence in the commission of the crime, unless the evidence shows beyond a reasonable doubt that such person committed the alleged crime, helped in the actual perpetration of the crime, or participated in the criminal endeavor. A jury is not authorized to find a person who is merely associated with other persons involved in the commission of a crime, guilty of consent in or concurrence in the commission of the crime, unless the evidence shows beyond a reasonable doubt that such person helped in the actual perpetration of the crime or participated in the criminal endeavor. The law provides that criminal action shall be tried in the county in which the crime was committed. In a prosecution in any case in which it cannot be determined in what county the crime was committed, venue is proper and may be proved in any county in which the evidence shows beyond a reasonable doubt that it might have been committed. Venue, that is, the crime was committed in Gwinnett County, Georgia, is a jurisdictional fact that must be proved by the state beyond a reasonable doubt as to each crime charged in the indictment, just as any element of the offenses. Venue may be proved by direct or circumstantial evidence or both. The state does not have to prove motive to prove murder. Any evidence of motive has been admitted for your use in determining the defendant's state of mind at the time of the killing. For the offense of felony murder, the state must prove that the defendant caused the death of another person by committing a felony. Aggravated assault is a felony, which I will define for you shortly. The state does not have to show that the defendant acted with malice to prove felony murder. You may find the defendant guilty of felony murder if you believe that he caused the death of another person by committing the felony of aggravated assault, regardless of whether he intended the death to occur. There must be some causal connection between the felony and the death. Felony murder is not established simply because the death occurred at the same time as or shortly after the felony was attempted or committed. The felony must have directly caused the death or played a substantial and necessary part in causing the death, regardless of when the death ultimately occurred. When a defendant unlawfully injures another person, you may find that the injury caused the other person's death only if the state proved that the injury was itself the cause of death, directly and significantly contributed to the cause of death, or significantly sped up the death, even though the death would have eventually occurred. Aggravated assault. For aggravated assault, the state must prove that the defendant assaulted another person with a deadly weapon. To prove assault, the state does not have to prove that the other person was actually injured. A firearm is a deadly weapon when used in the way a firearm is ordinarily used. For the offense of possession of a firearm during the commission of a felony, the state must prove that the defendant had a firearm on his person while committing a felony, which is a crime against or involving another person. Felony murder and aggravated assault are felonies which have previously been defined for you. For purposes of this particular offense, a firearm includes any handgun. If, after considering the testimony and evidence presented to you, together with the charge of the court, you should find and believe beyond a reasonable doubt that the defendant in Gwinnett County, Georgia, did on or about July 27, 2021, commit the offenses of felony murder, aggravated assault, and possession of firearm during commission of felony, as alleged in the indictment, you would be authorized to find the defendant guilty. And in that event, the form of your verdict would be, we, the jury, find the defendant guilty. If you do not believe that the defendant is guilty of one or all of these offenses, or if you have any reasonable doubt as to the defendant's guilt on one or all of these offenses, then it would be your duty to acquit the defendant, in which event the form of your verdict would be, we, the jury, find the defendant not guilty of the offense or offenses for which you do not believe he is guilty. We're going to send out with you a jury verdict form that has been prepared for your use during the deliberations. When you get it, you will see that there is a place for you to record your verdict for count 1, felony murder, count 2, aggravated assault, count 4, possession of firearm during commission of a felony, and count 5, possession of a firearm during commission of a felony. You have to render a verdict for each count individually. Your choices for each count are, we, the jury, find the defendant guilty, or we, the jury, find the defendant not guilty. So your verdict must be recorded in writing for each of these 4 counts. It then must be signed and dated by whoever acts as your foreperson during deliberations. By no ruling or comment that the court has made during the progress of the trial, has the court intended to express any opinion upon the facts of the case, upon the credibility of the witnesses, upon the evidence, or upon the guilt or innocence of this defendant. Your verdict should be a true verdict based upon your opinion of the evidence according to the laws given to you in this charge. You are not to show favor or sympathy to one party or the other. It is your duty to consider the facts objectively, without favor, affection, or sympathy to either party. In deciding this case, you should not be influenced by sympathy or prejudice, because of race, creed, color, religion, national origin, sexual preference, local or remote residence, or economic status for or against either party. You are also only to concern yourself with the guilt or innocence of the defendant. You are not to concern yourselves with punishment. One of your first duties in the jury room will be to choose one of you to act as the foreperson. The foreperson will manage your deliberations and will sign the verdict form to which all of you must freely and voluntarily agree. You should start your deliberations with an open mind, talk with each other, and consider each other's views. Each of you must decide this case for yourself, but you should do so only after discussing and considering the case with your fellow jurors. Don't hesitate to change an opinion if you are convinced that it is wrong. However, you should never give up an honest opinion to be congenial or to reach a verdict solely because of the opinions of the other jurors. During your deliberations, you must not communicate with anyone other than your fellow jurors about this case. You are also not permitted to conduct any research about the case, including any persons, places, or legal concepts mentioned during the trial. These rules apply not only to in-person communication, but also to communication or research using cell phones, text messaging, websites, blogs, or social media of any kind. Whatever your verdict is, it must be unanimous as to each of the 4 counts, that is, agreed to by all. The verdict must be in writing and signed by one of your members as foreperson, dated and returned to be published here in open court. Now, we have selected 14 jurors, but the first 12 jurors will engage in deliberations of this case. The 13th and 14th juror are our alternates, and they need to remain to us, and they still play an important role in the event that one of the first 12 jurors are either unable to continue or are disqualified from continuing for any reason. For the bailiffs, our alternates are juror number 27, Mr. Cate, and juror number 30, Ms. Mills. In just a moment, I'll have the bailiffs escort you to the jury deliberation room. You will have out with you the indictment, the verdict form, individual copies of the law, the instructions that I just gave you, as well as the evidence that was admitted for your consideration. If at any time during your deliberations you have a question for the court, the foreperson needs to reduce that question to writing and provide it to the bailiff for my review. Again, when you go in the jury deliberation room, the first thing you'll do is select your foreperson, and you will not begin your deliberations until you have received the indictment, the verdict form, the instructions on the law, and the evidence. From this point forward, you will decide when you need a break, how late you want to stay, things of that nature. So you will communicate that to the bailiff, and we will be on your schedule. I'll ask that you keep the alternates separate, but please give them breaks at the same time and bring them into the courtroom for any questions and a verdict when a verdict is reached. All right, I'll ask everyone to take your notepads and your personal belongings and to go with the bailiffs. It will be juror number 30, Neferteria Mills is the alternate. And if you'll grab that, Mr. Adderhole, that needs to go in the jury deliberation room. Right, just to clarify, there are actually 2 Miss Mills on the jury. That was juror number 22 and juror number 30, and I've instructed Mr. Adehold that the second alternate is juror number 30, Ms. Mills. Correct.
That's right, Judge.
All right, any exceptions to the court's charge from the state?
No, Your Honor.
From the defense?
No exceptions. Thank you, Judge.
All right, then we'll be in recess until we have a verdict or any questions.
Yes, thank you, Judge.
All right, thank you. Did everyone provide their cell number to the bailiffs or at least to the court reporter?
I'll hang out till
Last time, Judge.
All right.
I don't think I have.
And the state will need to make sure they have a laptop in the courtroom in the event any question requires the playing of any recorded evidence. All right, we're in recess.
Thank you, Judge.
right, on the record, we are back on the record in the state of Georgia versus Austin Tybre Ford. The bailiff has provided me with a question from the jury that has been marked as Court's Exhibit 2. It reads as follows: See/hear video of Austin Ford's testimony at Clayton County Jail with Detective Carter. Signed, Carlene Jesse, who is the foreperson, and she is juror number 8. Don't have a bailiff. Let me ask the deputy to show the note, please, to both sides. All right, so y'all double check me. I believe that's going to be State's Exhibit 70, and I guess it's going to be 70B.
Yes.
Okay, if you will get that queued up and ready to go, and I will propose an answer that I will read for everyone's approval. Is that about an hour long?
It's an hour and, yes, the whole thing is over an hour long. I believe I played 49 minutes of it. They were able to determine starting and or stopping points, or how much of it they want to hear. I think the only way to properly present it or represent it would be to start as begun and go until the time period, the time mark to which it was played before.
I need the bailiff to stop going in and out. Can you stick your head out? I need the bailiff in here, please. Mr. Lewis, can you approach and show my proposed response to both sides? Right, on the record, I have proposed a written response that I am sharing with both sides. It reads as follows: Yes, everyone will need to assemble in the courtroom to watch it in its entirety, collectively as a group. Signed by me, dated today at 5:26 p.m. Any exceptions from the state?
No, Your Honor.
From the defense?
No, Judge.
All right, bring in all of the jurors and the alternates, please. I'm sorry, show them my response and then bring the note back and the jurors.
Yes, Your Honor.
Judge, did you get the information that the jurors wanted to go until 6? Did you get that information?
Yes, but
Okay.
right,
Okay.
I don't know what
didn't you got it.
that means in light of this question, so.
Okay.
Follow-up question.
Let me have court reporter mark it as courts 3, please. Court's Exhibit 3 reads as follows: can we control the playback of the video? And that's an easy no.
Yes, Judge.
Does either side want to see the note?
That's fine. Thank you, Judge.
And let me give, I'm going to add to it and then read my response. So we estimate it's approximately 1 hour.
Yes.
So my response is to the question, which was, can we control the playback of the video? My response, no, it must be watched in its entirety, played straight through with everyone in the courtroom. It is approximately 1 hour long. Any exceptions to the response from the state?
No, Your Honor.
And hearing none from the defense. Thank you. All right, let me have Mr. Wooten show this to the foreperson, and if there is no follow-up, then they can come in.
Yes, Your Honor.
And may I have everyone just check their phones for me, please? Have the court reporter mark it as Court's Exhibit 4, please. Court's Exhibit 4 reads as follows: can we watch the video tomorrow morning?
That's fine, Judge.
I think they probably just want to see a certain portion of it.
That's fine.
Let me just have, before I formulate a more detailed response other than yes, let me have the bailiff step out and inquire of them if they are in agreement on what time they want to come back in the morning. So I can be more detailed in my response.
Technically, they ask if they can watch that in the morning, which means they may want to deliberate till 6, but we'll figure it out.
I would imagine they want to go home.
I'm likely to just send them home. All right, my response to Court's Exhibit 4 reads as follows. The question, can we watch the video tomorrow morning? My response, yes, we will recess for the evening. Please return tomorrow at 9:00 a.m. in jury assembly. Please remember your precautionary instructions overnight. Any questions from, exceptions from the state?
No, Your Honor.
From the defense? No, thank you. All right, and if you'll show them that, and then you can excuse them for the evening. They do not need to come back in here, but you will need to bring that note back in here, and you'll need to collect all of the evidence.
Yes, Your Honor.
And bring it in here.
Okay.
And here's 2 and 3. Just wait for 4 to come back. Christine, will you step and see if there's, out of the 3 bailiffs, if there's one that can just bring us the note and the evidence, please? Right, you can give Court's Exhibit 4 to the court reporter, and may I have the verdict form?
Yes, Your Honor.
All right, I will maintain possession of the verdict form overnight, and let me have the indictment as well, please. I will ask the state to take possession of the evidence overnight and to return it tomorrow. We will resume court at 9 o'clock with the playing of the requested exhibit by the jurors.
Yes, Your Honor.
Anything else from the state before we recess for the evening?
No, Your Honor.
From the defense?
No, thank you, Judge.
All right, I'll see everyone at 9 o'clock in the morning. Thank you. Have a good evening.